future that was transferred in 2015.
Heard Sri A. Dhar, learned counsel for the appellant, who has referred this appeal under so-and-so against a judgment and declared it so-and-so. Dismissing, huh? Admit, call for the records. Let steps be taken for service of notice upon the sole respondent by registered post with AD. Steps within 2 days.
My lord.
List of the 6 weeks along with receipt of records as well as some service.
Obliged, my
May it please your lordship.
Yes.
My lord, here has been a matrimonial dispute and a divorce petition was preferred in 2021. Till 2023, nothing happened. Now 2023, the other side came in before this honorable court with a transfer petition. Stay was granted. And thereafter, in January 2004, stay vacated, dismissed. Case went to the trial court below, my lord, family court. Nothing happened, my lord. A written statement over written statement, time and again it has been taken. Thereafter, without written statement, it was closed, then it was fixed for evidence. Now, evidence we have adduced. Repeated occasions taking time, as if, my lord, it's a matter of course of taking time. In spite of the fact that, my lord, Supreme Court now came in, and our High Court also came in with a notification.
What is this order 10-2?
10-2, my lord, will kindly see. That is the last order, my lord. Yes. Now, again, adjournment has been given, my.
But can you file an appeal?
My lord, for section 19, my lord, any order, my lord.
No, if it's an interlocutory order.
My lord,
Granting time is not a final order.
this
You
petition,
can definitely challenge, but you have to.
my lord,
by
there
way of
ought to
revision.
have been 227 also, my lord, because very objective with regard to a proceeding, my lord. Everybody have a right to speedy disposal of
No,
a
this
case.
is an appeal.
Appeal, my.
You can come under revision or maybe under 2 days superintendent's power.
227, yes, my lord, ought to have been come.
You do that. We can at least pass some direction
Yes.
for expeditiously concluding.
Withdraw and a liberty,
Yes,
or
yes.
otherwise, may I pray for allowing me to convert this case into a, my lord, to make an amendment and add Article 227.
No, don't let it not be structured in the form of an appeal.
Yeah.
Present is in the way for revision.
Yeah.
Heard Sri A.K. Bhuya, learned counsel for the appellant, who has preferred this appeal under section 19 of the so-and-so. Full stop. We have, however, noticed that the order sought to be impugned is an order by which adjournment has been granted. Full stop. We are of the opinion that though a party may have a grievance against such an order, comma, the same cannot be the subject matter of challenge by way of an appeal. Full stop. At this stage, the learned counsel submits that he would like to withdraw this appeal and present it in the manner prescribed.
Yeah.
Para. The appeal accordingly stands dismissed and withdrawn with liberty as prayed for.
Liver, deeply.
What is three?
Just come up for admission for the first time.
Who is this counsel? Legal aid?
The PJ, no, it's a regular appeal. PJ, Jamar, Guru. Take it up after some time.
None appears for the appellant on call, whereas Ms. Jahan learned APP is present. Para. In the interest of justice, matter is adjourned to be listed after a week.
It's statutory appeal only.
Third, Sri J. Pine,
This
Learned
POCSO.
Learned Counsel for the appellant who has preferred this appeal under so and so, no? Against so and so. Para admit. Para call for the records. As Jahan, respond number 1, state steps for 2. POCSO, POCSO to be routed through the steps within 2 working days. List of the 6 weeks. And for some receipt of records as well as service. Huh? You have IA also?
Yes,
This is an application under so and so Likhiba. So the connected appeal has been admitted today. Then issue notice 6 weeks second. Step second round.
notice to
I'll file
respond,
my,
notice respondent.
Yes. Notice you are issuing, but she is accepting for 1. 2, you have to take steps.
Yes, ma'am.
That-
Full.
Identify.
May I please note it? Notif, I am appearing on behalf of Mr. A. Kalda, my custody, Notif. Notif, we have accept copy, Notif.
please for respondent, A. Gupta.
Where is Mr. Ahmed? Ahmed. Regular appeal, madam?
Regular.
POCSO.
Perhaps-
POCSO.
perhaps
Not Pokta.
Then.
POC-
341. 302.
Paper
340.
ready, Lordship,
Yes.
fix it for
Ah.
hearing.
None appears for the appellant on call. Whereas the state is represented by Ms. Ad Jahan and the private respondent by Sri Ann Kolita.
Yes,
Para. Since paper book has been prepared, list this case for hearing expeditiously.
2019 matter. so
Yes.
it's come.
6.
Here also paper book is ready.
Here in this case, as per Lahore court order, the service on the victim is complete, like POCSO matter. So, amicus curiae may be appointed.
Third, Sri A. Ahmed, learned counsel for the, you're the amicus?
Amicus.
Learned amicus query for the appellant who has referred to the order dated 10/2/2025 passed by the learned Lawazima court with regard to the service of notice upon the respondent number 2. Para, peruse this same para. The service upon the respondent number 2 is held to be complete. Full stop. Since the respondent number 2 has not entered appearance and the conviction and sentence being involving the POCSO Act, we appoint Sri N.J. Das, serial number 9, as the amicus to appear on behalf of the respondent number 2. Para, let a copy of the paper book be furnished to Sri Das by the registry within a week and the matter be listed for hearing in its turn.
Here in this case,
The name of the newly appointed amicus curiae be reflected in the cause list.
here in this case, juvenility was claimed, Lord. So, and accordingly, inquiry was directed, inquiry report has come, it has come in his favor, Lord. So, my prayer is that, Lord, after serving the copy to the amicus curiae, Lord, the date may be fixed for hearing on that, because it is, as per report, he is juvenile at the date of the death.
Second last line to Nalikiba. We served upon within a week, As the issue of juvenility has also been raised, list this appeal for consideration after 3 weeks. Please inform personally. We have appointed whom? N.J. Das.
And obliged.
Item 7.
Yeah, please, Lordship, in this matter, otherwise the paper book is ready. And we have already taken step for service of notice upon response number 2. And a report was called from to the PP.
Involving POXO.
Yes. So a report was also called to the PP.
I'll get the instruction.
Okay.
Yeah, I don't.
Part 3, U. Chaudhary, learned counsel for the appellant, as well as Miss S. Jahan, learned APP for the state. On the prayer of Miss Jahan, the matter is adjourned by a week to enable her to obtain instructions on the aspect of service of notice upon the response number 2.
Obliged.
My pleasure, Lord. My Lord, in this case, Lord, we have received objection from the respondent number after before some time, Lord. And objection from the respondent number 2 is yet to receive.
To
I have
legal aid
given up.
counsel, you may not be interested. Will you file objection?
Every-
You rely
everything
upon the.
already-
Okay.
Lordship. In that case, Lordship may kindly take up the matter of Lordship on 20 time frame because senior counsel is engaged here.
Who is the counsel?
Mr. PJ here.
Okay.
I am instructed.
Okay. On a prayer made on behalf of the appellant. Matter is adjourned by a week.
Lordship, date may the 28th, Lordship.
A matter is adjourned to be listed. A matter is adjourned and on request, the same is to be listed on.
28. Yes, 28.
Okay. 28,
Obliged, Lord.
28-3.
Item 9.
To present to the Ms. S. Jahan, learned APP, and Mr. Ansri U. Chaudhary, learned legal aid counsel for the respondent number 2 are present. Item 9,
M. Rahman,
M. Rahman,
state,
and appears for the appellant on call, whereas Ms. S. Jahan, learned APP, is present, para, in the interest of justice. Matter is adjourned to be listed after a week.
our object.
Item 10.
Yes, Your now in this case, Lordship, appeal against equitable lot. And the service report Lordship, that it returns due to insufficient address lot. And may I pray, Lordship, I may be allowed to allowed to take first step after verifying the address lot.
You're for the appellant.
But I am
Oh,
you.
yes, sir.
Thank
This
you.
is equitable.
against
On the prayer of Re A. Ahmed, learned counsel for the appellant, matter is adjourned by 2 weeks to enable him to verify and take fresh steps upon the private respondents list after 4 weeks, along with service report.
obliged.
May I please, Your Lord?
Yes, Mr. Bora?
Here we have not received an objection from the respondent number 2. ma'am. They were
We have-
about to file an objection.
We have. given up.
Yes.
Yes.
We have received from the statement.
You will file, you are for this one number 2. Will you like to file objection? You'll like to file within a week? Okay. Heard 3D Bora, learned counsel for the applicant appellant, who submits that while objection has been filed by the state, comma, such objection has not been filed by the respondent number 2, para. Also heard Ms. S. Jahan, learned APP, para. Sri Sattar, the learned counsel for respondent number 2, however, submits that objections would be filed by the respondent number 2, for which he prays for and is granted a week's time. Para, list after a week, along with
Obliged.
objections that may be filed in the meantime.
Obliged.
Your objection is on record?
It's on. You'll see the text. I can hold on. So that is not there.
None appears for the petition, none appears for the appellant on call. Whereas Ms. Ed Jahan Learned APP is present, para. In the interest of justice, matter is adjourned by a week.
Fairly fast for timing. Only.
Timing is not possible. What is
In fact, there was a composite appeal at the first instance.
Mr. Lal, your matter is gone. Where are you? Should have
Well-
somebody. Will come after a week. If there is some urgency, we can reconsider.
That's the only thing, Milord, I need to take first step in the matter, Milord.
Hey, I'll go to DSM. Just a minute. Should have somebody in the court.
Lordship, my apologies. Records have come, Milord. So respond number
Part
2.
3A Lal, Learned Counsel for the appellant. Why do you need to take first step? She'll take instructions.
I'll have to, if he has taken, I'll take instructions then.
Yes.
Lordship, the respond number 2, Milord. She needs to appear, Milord. So we can take, Milord.
No, you have already taken steps. She'll get the
I'll
instructions.
get the instructions.
As well as Miss Ed Jahan, Learned APP, para. Pursuant to the order passed by this court, the records have been received. Full stop. Para, on the prayer made by the Learned APP, matter is adjourned by 2 weeks to enable her to obtain instructions on the aspect of service of notice upon the respond number 2.
Deep apologies. And my apologies, Lord. Sorry, but
As far as 13 is concerned, it was a composite appeal initially.
Hmm.
Thereafter, it was separated because the sentences were different.
Okay,
2 of them were awarded life sentence, rest were all 7 years, 5 years and all.
okay,
So it was separated now.
okay.
Initially, it was a composite appeal.
Hmm.
Therefore, it has come up after separation for the first time.
Okay. A paper book prepared.
No, not prepared, not prepared. Even I have to file my objection. As far as Sohrab Ali and Bodiud Jaman is concerned, they are awarded life sentence.
And along with these appeals, I has also been filed.
I also
Okay, you
been
file
filed.
objection? Okay.
I'll file my
Okay.
objection.
I 13, huh?
But the fact remains that the rest of the appeal, Sopur Ali and Anwar Hussain,
May go to
they
the
should
single bench.
actually go to single bench.
No,
sir.
but this will not be proper. One, we'll consider. Because otherwise also, there is appeal only to the Supreme Court.
Yes.
So no prejudice as such.
But-
It's not like a writ appeal. On the prayer made by Ms. Ed Jahan, Learned APP. Matters are adjourned by 2 weeks to enable her to file objection in the applications. Okay. The IAs, application have IAs will use. IAs. 14.
May I please your lordship? My lord, this interlocutory application 167 number is filed for suspension of the sentence, my lord.
Notice has not been issued come for the first time. We'll issue notice here.
Lordship, yes.
Appeal has been admitted otherwise.
Yes, my lord. So that may be fixed for the appeal hearing and also with the bail application. And in the meantime, I shall take steps for the respondent number 2, my lord.
No, I have to issue notice.
Yes.
In the IA and in the appeal will direct records have come.
LCR is available. Records are here. LCR 2 files are here.
Heard Miss B.R.A. Sultana, Learned Counsel for the applicant, who submits that the connected appeal has been admitted on 1/10/2024 and records were called for, pursuant to which order, comma, the records have been received. Para, issue notice returnable by 6 weeks. Miss Jahan, learned APP. Accepts notice on behalf of the state respondent. Let steps for service of notice upon the respondent to be taken within 2 days. The service is, however, required to be routed through the office of the learned public prosecutor Assam. Para. After 6 weeks, by the returnable date, the learned APP shall obtain instructions on the aspect of service of notice and may also file objections if so advised. Para. Since the trial court records have been received, comma, office to go ahead with the preparation of the paper book. Implemented. 15.
Please, this interlocutory application for condoning the delay of 198 days when the
First
filing
time. First time.
date. First time.
Heard Sri R. Islam Learned Legal Aid Council appearing for the applicant who has filed this application under Section 5 of the Limitation Act 1963 for condonation of delay of 198 days in preferring the connected appeal. Para. Let notice be issued, returnable by 6 weeks. 302 or what?
POCSO.
Well, POCSO is there and kidnap is also there.
Miss Jahan Learned APP accepts notice on behalf of the state respondent. Let steps for service of notice upon the respondent to be taken within 2 days, which is to be routed through the office of the public prosecutor Assam.
Obliged.
Delay will be condoned, no problem, but it's a matter of formality. We have
Yes.
to issue notice. 16.
Map is up. Appeal again. Map for the correct.
Yes.
Doesn't matter. We have also received just now.
Arms acts are involved,
Hmm?
sections of arms.
By the
Act.
time he prepares, you also make your preparation. You will take at least half an hour. Madam doesn't need half an hour to prepare.
I'll do my part tomorrow.
No.
No,
Today,
let us see, my lord. Yes.
no spilling over. How many witnesses?
Witnesses, my lord. 11 witnesses.
11 it is, okay.
Or if he wants time,
No. We don't have, this is the last matter.
Lost.
Cannot waste time.
Lost. To mark with.
Unless there is some grave difficulty on either part.
No, man. Otherwise, no
Not
difficult.
prepared, those things will not matter.
Yes.
We are also not prepared.
Man. Yeah, my lord, case is that, my lord, initially a
Just
case
give us 2 minutes time.
lost. So, mark with. Hello, mark.
Yes,
Case is that, my lord, initially, my lord,
history, history.
my lord, there
Hmm.
was a case, my lord, criminal case, that, my lord, was acquittal, my lord, for full test trial was there, my lord. Again, my lord, that criminal petition was done, my lord, of his own motion, my lord, then it has set and retrial, my. Then, my lord, we got convicted. My case is that, my lord, I am the constable, my. I have been issued some numbers of arms and ammunition, my lord, which I have returned. The core issue is that, my lord, the bullet, my lord, which has been recovered from the spot, and bullet of mine, my lord, for official duty has sent for the FSL does not match. That is the only core issue.
Okay, come to the FIR. Let us begin.
Lordship will
History.
see the FIR,
History.
Lordship. I have the honor to state that at about
This
11,
Ananda Borthakur is PW1.
yes, Ananda Bhattakur, informant, he is working in cinema hall or somewhere. Not
Okay,
we,
please read.
but he is not there in. I heard the gunshot, followed the
No, no,
condemnation.
please read from the. I have the honor to say at
I have
11.
the
Honor to state that.
I have the honor to state that at 11 a.m. on 20 August 1999, prior to the starting the morning show at University Cinema Hall, situated at Ganakwa, I heard a gunshot followed by a commotion inside the premises of the cinema hall. When I inquired about the matter, I learned that the unknown person shot and unting the scene. Thereafter, the boy was sustained gunshot
Who sustained?
that
The boy who not was. Who sustained?
that the victim, man.
Thereafter the boy who sustained, not was sustained.
Achha, my lord. Thereafter, the boy who sustained the gunshot
Yes.
found succumbed to his injuries. Inquiring about the identity of the victim, I discovered his name is Ranjan Nath. His name is Ranjan Nath. He belonged to Kaburu village. Therefore, I pray to investigate further. Thereafter, my lord, thereafter, my lord, after completion of my lord, at page 5 and 6, charge was framed.
Hmm.
5, my lord, past charge on 29/88 at 11 a.m. did cause death to Ranjan Nath in front of the Urvasri Cinema Hall by shooting him with a pistol bearing number so and so. Lordship, kindly note down that, my lord. Pistol number bearing number so and so, we intend to kill him. And whereby committed the offense punishable under 302, cognizable of the. Secondly, that you aforesaid date and place illegally possesses 19 mm service pistol bearing number so and so. Bearing number so and so, and hereby committed an offense punishable under section 27 of Arms Act. Then, my lord, the case was committed for the learned competent court, that is the session court, my lord. Accused person copy furnished and this thing and case was forwarded. Thereafter, lordship will see, my lord. So coming to that, my lord, I like to draw lordship's attention at the impugned judgment. My first judgment, my lord, it starts from page 75.
We read the depositions.
That,
That can be an additional point which you can argue.
yes. I'll come.
Page
PW
8.
PW5 is very important, my
Okay,
lord,
we did-
but I'm going chronologically.
Yes,
my-
Page 8.
Page 8, my
PW1.
PW1,
Informant.
informant. In the morning of August 20, 1999, I was booking at the counter grocery cinema hall located at FG Road, Golaghat town. Hall is situated on the right side of TF Road. There is a wall around the compound of the cinema hall. Ticket morning show were being sold on that day. It was 11 a.m. Then I just heard a sound resembling gunshot inside the cinema hall compound. Immediately afterward, the people gathered there began to run away in various directions from the compound. As I came out of the counter, I saw boy lying wounded in the hall compound. I quickly made a phone call to Golaghat PS to report the incident. Police promptly arrived at the place of occurrence and started investigation into the matter. I lodged a written Ezahar. Exhibit 1 is the signature which I lost in my signature. I came to know that the name of the injured boy was Ranjan Nath. I saw the accused who is present today. When the police had taken him to the compound of our hall in connection with the incident, I don't know him otherwise. One cartridge of 9 AM pistol was recovered and seized from the cinema hall. Exhibit 2 is the seized. That is the important, my lord, which has been sent for FSL. Exhibit 2, one is the signature. Police took the injured body to the hospital. Then cross, my lord, I did not see who fired the bullet. One line, my lord. Thereafter, my lord, PW2. PW2. I knew at page 10, my lord. I knew Ranjan Nath. He was my classmate. I do not know the accused. On 20 August 1999, we went to college on usual, but the classes were dismissed early due to the demise of the college staff. Thereafter, Ranjan Nath invited me to watch the movie with him. When I declined, he insisted I go with him to check out the posters of the movie being screened. First, we went to Chitralekha Cinema Hall to see the poster, and after that to Urbasri Cinema Hall. It was forenoon then. A lot of people gathered in the cinema hall compound to watch the morning show. I went there by bicycle. Due to the large number of people inside, I stood at the entrance with my cycle, and Ranjan entered into the cinema hall compound. He came out of the hall's compound. Once he entered it again. After a little while, I heard a sound of gunshot being fired with the hall's compound. People started running away from the hall's compound. When I could not find Ranjan, I asked people who said that the boy had, had been shot in the hall's compound and asked me to check him. Arriving there, I saw that Ranjan is lying ground with a bullet. I informed the member of the Ranjan's family, whom I found at the early nearby shop, about the incident and headed towards the police station. Subsequently, I went to the Golaghat hospital. I learned Ranjan has already expired. In cross, my lord, I did not witness how the incident took place. He also does not know. Then, my lord, PW3 at page 12.
Page?
Page 12. It is a constable, constable number 124. I know the accused. We worked together at the same place on 29/8/99. I was working at Golaghat Police Reserve, where the accused also was. On that day, we were both off duty. On that day, at around 11 am, I, along Procedural Bora and the accused, went to the Golaghat town in a vehicle to watch the movie. When the vehicle stopped, we got off the vehicle. Procedural Bora went to the market to buy some clothes. The accused and I went to cinema hall to watch the movie, where we were wearing civil clothes. The accused waited outside the cinema hall while I stood in the queue inside the hall to buy tickets. Because of the crowd, I left without purchasing ticket. Then I was near the entrance gate. I heard the sound of the gunshot and quickly left the place. When I arrived at the police reserve, I learned that the boy, boy had died as a result of being hit by a bullet. Later on, I learned the accused had killed the boy on 8/9/99. 8/9/99. I made a statement in the court in connection with the incident. Exhibit 3 is the statement. Exhibit 3(1) are my signature. On that day, large crowd on Cross Mile. On that day, a large crowd gathered the cinema hall. Accused followed me inside. I stayed the barrack. I did not observe the direction from which the gunshot was fired. It is not a fact that I deposed falsely about hearing the accused had fired the gunshot. On being instructed by my officer, I have made the statement. Then, my lord, PW4, Vatsal Gopal Goswami. And there is, my lord, subsequent development that, my lord, is very person PW3. He deposed statement, again he deposed statement, and there, my lord, he said that because of the SP, my lord, he was given stick. That I'm coming. Now, lordship will come to the page 14. It is PW4, is the doctor, my SDM so on 28/99, I was SDM Golaghat Hospital. On that day, I performed the postmortem examination of the dead body. The Ranjan Nath spotted by TN number 45, Ranjit Musahari, and identified by Sir Rajit Musahari and Dipesh Nath, found the following rigor mortis present. The gunshot at the back of the neck, upper right side, wound is entrance is 3 foot inch, irregular lace leaves the head, blackening of the edge of the gunpowder, track of wind direction towards the front, enter the bullet activity, the tear in the tongue and wounded the parallel bone in front of the breaking tree front inside the teeth, could not exit irregular, but 1 inch injury clavicle vertebra, 2, second and third with injury spinal cord. No injury on brain and scalp was found. Mouth cavity right side of the breaking chain of the mandale and with splitting tongue. Heart break the maxilla. There is no injury on other organs. Because of that, due to the shock hemorrhage of the injury, antemortem. PW Exhibit 4 is the PM report. PW1 is the signature. PW2 is the signature of Dr. Bortola, Joint Director, Health Service, Exhibit 3-4 is the signature of Dr. Karen Bora. Now crossword. I opened the injury gunshot was found of powder. I did not examine the powder found in the injury. I have not mentioned the age of the injury. It is not a fact the injury found are not gunshot injury. Then, my lord, PW5 is a very vital, my lord, in the case. I have been, this, my lord, Ambassador Bora. I have been working as a armorer at Gola Guard PS 1994. The accused worked as a constable in our department on 19/8/19. When the accused was commanded to perform duty, I handed over a 9 AM pistol, 12 rounds of MME Curtis magazine on 28/99. Then page 15, my lord. The accused returned the state ammunition. Exhibit 4 is the arms issue register of the Golaghat. Exhibit 4-2 are the concerned entries regarding the issuance of the gunpowder. In the signature of the accused, investigation officer sees Exhibit 4 registered from the custody of the Pro Exhibit 5. Yeah, 5-1 is my signature. Investigation officer also sees the arms which were issued to the other police personnel by Exhibit 6, 7, 8. Exhibit 6-1 is the and Exhibit 7-1 and 8 are my signature. I keep the article in my custody after the same has ceased later. I produced the state article in the office of the PI. Material exhibit number 1, 2, 3, and 4 are the pistol. I received. Lordship will have to examine, my lord, this bullet and the bullet found with the dead. Number I'll give. I received the pistol and 12 rounds of ammunition and magazine back from the accused. The accused did not fire any bullet. The pistol number so was issued in the name of Jayanta Bora. I received the said pistol on 21/8/99. Incident on 20th. I have adduced evidence on the basis of Exhibit 4 on 8/22/8/99. The SP came to inspection and put his signature on the register upon finding everything to be in order. The investigation officer sees those articles on 5/9/99. All the items except the pistol number were seized on that day. The said pistol had seized on 22/8/99 at the time. The said pistol were freshly brought in, but the ammunition has already been brought in earlier. I did not find any sign of use of two pistols when I received back. That is the crossword. Oh, itu gimana, Bu? FSN nih. And now, my lord, Lordship will see simultaneously, my lord, the chart page number 5, my lord, the framing of the charge bearing pistol number, my Lordship again turn back to page number 5. Pistol, service pistol bearing number 161-20790. Issued to Jayanta Bora as per PW version. For pistol number 2. Crossword position, huh? Crossword. Oh, no, I'm a crossword. Now, Lordship will see in the charts and page 18, my 5 and 18. The very gun was issued to Jayanta Bora, 161-20790. 161-2790. So does not match with the chart, page 5, the chart and the deposition. Then lordship will come.
Just a minute, just a minute.
Paniya.
161-20790.
My lord.
It is matching. Numbers are matching,
Numbers are not.
matching.
It was not issued to me.
No, it was issued to one joint Bora.
Joint of,
That is okay.
and that is joint of.
Uh-huh.
Number is the same, but not to me.
Hmm.
Joint of.
Hmm.
And whatever, my lord, I have taken that he has received it. That will come, my.
What
Then
was the
lordship will-
number? What is the number of the pistol which was issued to you? Has it come anywhere in record?
in seizure list, my lord, maybe we'll check it up.
But till now, I don't think that has come. The
Seizure list
pistol,
is
which
what?
is the subject matter of the charge, was issued to one joint Bora as
Joint
per the deposition of PW 5.
5.
Correct.
He is the issuing officer.
He is the Havildar.
How is that? No? To কোন seizure list to put airport লগত পাইছে এইটো দিয়া আৰু আমাৰ পৰা লোৱা seizure list exhibit 4 হ'ব তিনটা কিমান হ'ব এইটো FSL এইটো বেলেগ বস্তু এইটো কি FSL এইটো নালাগে আমাৰ seizure টো লাগে FSL টো পাছতে কোনটো seizure list কিমানটা আছে তিনটা lordship will check it up my lord seizure list it starts from 97 to 101 100 Bye-bye. Anwar, Pania. Over. 97, my lord, it is also seizure list, my lord. A.K. Sahu of the Kalaga 2 hereby sees the following descriptive forms number of the bearing produced by Ambedkar Howldar Ambassador Pora magazine card police reserve so 1 mm boring pistol itu number mili 1612797 page 97 be seen my lord. One six one two
How
zero
many pistols have been seized?
three or four.
Four pistols.
That we, these are the seizure list. There I have. Then 161-20790 with 1 my lord. It is been given
3 pistols and 4
30.
rounds of 9 mm ball and
Then my lord,
Just
This-
a minute.
97 it is being recovered from Amedar Howldar,
70.
investor Bora of the magazine police reserve Golagat material exhibit 1. Right up. Then my lord, seizure list 99 is another pistol.
4 pistols.
Yeah,
Not
four.
3. 4
Four.
pistols.
Then
You
my
come
lord,
to first, madam, you come to first 97. 97 is the pistol of Jayanta Bora. 161-20790. Correct? Kindly turn over the page, 2 pages, come to page 99. 99 is description. Number 1, pistol 162-37182. Some second pistol. Then thereafter, third pistol 162-36901, third pistol. Turn over the page. This is the fourth pistol. These are all different numbers. 4 pistols. 4 pistols seized.
my lord. And some
Which pistol was allotted in your name?
yes, my. That is not clear from
the Havildar has deposed of a pistol which was in the name of Jayanta Bora.
Yeah.
And that pistol has been examined and it doesn't appear that it was fired
Yes.
recently.
And FSL also sent my lord some different number of cards. It was issued to me.
Different numbers of?
Cartridge number, my
Okay,
lord.
okay. Cartridge.
That will come, my lord, because then the body they have recovered one cartridge. Now, lordship will see. Now we were on to PW5, my lord. Now 6. PW6 at page 20, my Ajit Pal. I have been running a pawn shop outside the Urvasri Cinema Hall at 11 a.m. one day, approximately 5 years ago. I heard a loud sound resemble the bursting of a tire. Then I noticed the people running in different directions. A little later, I saw a person lying dead in the compound of the cinema hall. Exhibit 2 is my signature, which I put and asked by the police. I don't know why the police obtained my signature. Then, my lord, at page 22, PW7.
Who is this Ajit Paul? He's a pawn shop owner.
Yes, my lord. Is the pawn shop. Ajit Pal is the pawn shop. Then, lordship will see PW7 at page 22. It is Orun De. About 5 years ago, I ran a pawn shop outside this is also pawn shop, cinema hall at Raganagat at 11 a.m. One day I was in at my shop. I heard a loud sound like a tire bursting and I saw people running at different directions. Later, I noticed the person lying dead inside the cinema hall compound. Exhibit 2C is my signature, which the police obtained from me. I do not know why the police obtained my signature. Then lordship will come to page 24. It is PW8. And he has examined the FSL map. PW8 is the forensic authority map. Page 22. His name is my lord Apurva Kumar Sharma. On 24/9/99, I was senior scientific officer, Bilastic Division, FSL, Assam, Guwahati. On that day, I received one steel wooden box from Chief Judicial Magistrate Golaghat Pro Director FSL in connection with the Golaghat case number. Opened the wooden box and found following. Now, lordship will see my one fired 9 a.m. cartridge okay. Mark is okay, mark. In the bullet, my lord, there has to be some mark. Okay, which is marked by us as exhibit 1. 9 a.m. pistol. This, my lord, again, my lord, the same pistol was shown, my lord. That 161270 magazine. I examine following the result. Exhibit 2 is the fire service test report. Test firing were done through exhibit B. Finding impressions on the last test cartridge were compared with the exhibit A. Under the comparison microscope, we found two eligible dissimilar. He also found dissimilar. Hence, it may be concluded the exhibit A was not fired by exhibit. He confirmed pistol and bullet. It was not fired from that particular pistol 101620. On 6/9/2099, I received one box from Superintendent of Police Golaghat in connection with number so and so. Opened the box and found following articles. 19 mm pistol 16162 with a empty magazine at exhibit A2. 19 pistol 162 6901 empty cartridge marked exhibit B2. 19 boring pistol 161 with empty cartridge exhibit C2. Then my lord 15 round of pistol marked test D2. I examined and found the following. Testing firings were done pro exhibit 1, exhibit A2, B2, C2 by using cartridge exhibit D2. Firing pin impressions of the exhibit 2, 3, 2B, A, 2B and C2 were compared with the firing pin impression on exhibit 1, which was received by memo number. The firing piece from impression on the test cartridge fired pro exhibit A2 and exhibit C2 and exhibit A. That is the cartridge of memo number so and so were found to be dissimilar. He found dissimilar. Finding pin impression test cartridge fired pro exhibit B2 is boring pistol number so and so 901 is found to be similar that of exhibit A. Exhibit cartridge case memo number, hence it may be opined that the exhibit A was fired the exhibit B2. The empty cartridge number exhibit so and so. It is not a fact that the steel box was intact sent by superintendent of police. It is not a fact. I mentioned that exhibit A in my report, exhibit 10 without examining exhibit A. This is not a fact that the exhibit 10 is the fact report. I did not examine the barrel. Now lordship will see. Yes, and very person, my lord, also deposed, my lord, earlier occasion. Lordship will see page 58 is 57, my lord, the very person. Then lordship will see 58 cross part. I deposed the evidence to date in connection with the so and so ethylene box not received by us. I did do not examine the fingerprint or thumb impression, only examine the arms and ammunition microscopic. The fingerprint do not. Then lordship will see page.
But he has said this cartridge, OK cartridge, exhibit A, was fired by the exhibit B2. That much matching is there.
But whatever sent to the FSL, that is not, that I'll come, my lord. Okay, and that too, my lord, that I'm coming, my lord. Now lordship will see page 27, that is PW9. On 22/8/99, I was working as the reserve police at the police Golaghat. The accused working as a constable in our department. On that day, when the Havildar Ramedar of Golaghat Reserve produced a 9mm pistol before TSI Shahu in my presence, I put.
This person was what?
He is also employee of maybe police, my lord.
RO means reserve, where I am. What is
TSI, my lord, is a police person. Shahu.
Working as the reserve officer.
Reserve. Then, my lord, next page 28, signature in the exhibit 6 is my signature. Material exhibit 4 was that pistol. Material 4 to sides. Material exhibit 4. On safe day, arm issued and registered exhibit 5. The teacher list 5. signature. Exhibit 5 was the registered on 25/8/99. Ammunition of 9 mm pistol was seized by Exhibit 8. Teaser list 85/8 in my so are those pistols. In fact, metal exhibit 4, the pistol was not the same pistol which was seized through exhibit 6. So Lordship has to see 4, 6, এখানে কো exhibit 4 লাগছে exhibit 6, 5, 6, 8 after. Yes, what like it. Now Lordship will see page 29. It is the PW10. Arun Kumar Sahu, Ajit Kumar Sahu, Inspector of TPC Dergaon. On 22/8/99, I was working at Golaghat Police Station. N.C. Gogoi was in charge of PS then. On that day, as mentioned in the entry number 637 of General Diary, telephonic information was received from one Uttam Kumar Nath to that effect that one person had been shot that inside the campus of the Urbasri Cinema Hall. Then the OC accompanied by myself and other staff went to the cinema hall and found one person lying there with injuries. The injured person was sent to the hospital. Empty cartridge of 9 mm. 9 mm pistol was found and same was seized. I drew the catch map, place of examine the witness. Injured person died in the hospital. I went to the hospital, learned that the name of the injured person is Ranjan Nath. I had inquest and sent the body to for PM examination. Exhibit 11 is the exhibit, is my signature. Later on, Exhibit 1 Azahar was registered. Exhibit 2 is the seizure list. Exhibit 2 seizure list. I seized the arms, register book and Golaghat. And Exhibit 6 is the seizure. Exhibit is the signature. I seized the list of so and are by signature. I seized the some document through Exhibit 5. The seizure list and in my signature. The accused police constable and thereafter completing the investigation, I found sufficient incriminating material against the accused. Filed the charge sheet against him. Exhibit 12 is the charge sheet. 12 one is the signature of Prabit Datta SI, and I am familiar with Exhibit 12. Then cross mark. The arms which were seized, Exhibit 7. So, the seizure list were not sent to the FSL. So the Honorable Court. The place of occurrence told the executive magistrate, but no report was prepared to that effect. It was not the fact accused did not show the place of occurrence to the executive magistrate. কোন কেস সেকেন্ড কেস হ্যাঁ এটা ফার্স্ট কেস and my lord page 32 it is seen again my lord 20 December 2008 my lord again PWs were examined. It was done, my lord, earlier occasion. Lordship kindly have a look at the spot on tip.
Which
Page-
one? Page 32?
Page 32. Again, PW1 has come, my lord, maybe before the earlier round of letting. First case or second case? agree. Now, my lord, again 2008, my lord, PW one was,
No, who's this PW one? He is not Ananda Borthakur.
no,
I
my
think
lord, maybe for,
No, he should be 11, I think. Should be 11 after
no,
9.
my lord,
After
PW 1, 2 again, my.
No, Samanta was examined earlier.
My lord, the after maybe my lord case was remanded back by Honorable High Court, my lord. Maybe the second time has been.
Samanta was earlier examined when?
PW 2,
On June 2023, 2003.
3. Now, my lord, 8.
Second, why is it again examined?
Second examine matter was remanded back by the High Court to go for a re-examination of entire case.
You have that?
Yes,
Order?
order reflects. Judgment is also there, my lord, and order of Honorable High Court, some portion is there, my lord, in the judgment is. Now, my lord, for the second time, my lord, lordship will see the cross part, my lord. So, more or less, lordship has come across page 33. PW1, my lord, of 20th day of December 2008. In cross, he said, previously,
Let us see the order of the court.
order of the court of first trial, my lord.
No, High Court.
High Court, my lord, in the impugned judgment, there is some reflection, my lord.
Lordship, please.
Para 5. No,
Honorable Guwahati High Court, para 5, by judgment and order dated 7/8/2007 in criminal revision suo motu number 174 of 2007.
For a fresh trial.
first
Was
trial.
pleased to set aside in so and so. That's it.
Pass the learned session judge,
Please to observe the
Golaghat,
following.
Honorable
Fresh
High.
trial.
Ah,
If it's a fresh trial, the deposition which you have just read, will it have
May
any
not be
relevance?
relevant.
Will not be relevant.
First, this one will have, my
Now
lord, after the judge.
Yes.
Yes.
The one you have read perhaps will not be
Earlier.
relevant.
Yes, my lord.
Because
Anyway, my lord.
that stands interfered with
Yes.
by the order of the High Court.
Yes,
And matter was sent not for a reappreciation, but for a fresh trial. That
Fresh.
means fresh evidence.
yes, my
And the order of evidence has also changed. PW2 earlier, Samanta Bora has become now PW1. So let us, I think,
Lordship, Honorable Court on earlier occasion directed a session judge further directed to frame appropriate charges in the light of this order
Hmm.
and on the basis of the material which is already in existence on record of the court.
Hmm.
Okay, so,
the charge would have to be properly framed and
yes,
thereafter a fresh trial.
yes. So, Lordship, 5/4/2006.
page number 5. Then. Paper book,
So,
page 5.
Well, wait for
Yes, yes. No, 8 to 5 pages. It is the
then at the next page, so page 6 to
Ah,
12/8/2008.
yes.
I think page 32 onwards would be the relevant
Yes.
evidence now.
Page 6 will be,
Page 32 onwards.
my lord, 32 on.
PW1 again.
Again, my lord, please. Now, name change, my lord. Samanta Bora. I do not know the accused. I know the complainant Ananda Bhattakur. This is Ranjan Nath was my friend at 11:12 p.m. noon. On 20th, he died in Cinema Hall, Veganapara, Golaghat. He was shot at on the way. On the day of incident, I accompanied the Ranjan Nath to Cinema Hall to watch movie. On that day, the classes were dismissed as early and to demise of the college staff. Ranjan Nath went to almost same month. When I at the eye of his bicycle to the roadside. Ranjan Nath entered the cinema hall. He came out wants to tell me, wait, then we went back after a little while. I heard the sound of gunshot. People started running.
Hemanta Bora is this friend of the deceased,
This is
classmate.
he was there in the college. I said, I started to the Ranjanath. I asked the unknown person and could locate my complainer Ranjanath. He told me to have a look at the boy who was lying inside the cinema hall compound. Then I going there, I saw Ranjan is lying with prostrate on the ground inside the cinema hall compound. He was covered with the blood and being helpless. I rushed the Ranjan house Bongaon. On that day, I informed the cooperative shop of the site by the road of the incident. I, along with Ranjan's uncle, went to Golaghat police station, but I did not find Ranjan there. Then Ranjan's uncle and I went to civil hospital, found Ranjan's dead body covered with a white cloth. I do not know who shot the Ranjan. The police questioned me. Then crossed my page 33. I previously testified in the court in connection with the case. My earlier statement, I said all the things which I have stated today. At the time of incident, I was not inside the cinema hall. I do not know who shot Ranjan dead and how the incident occurred. Then page 35, my lord, is Ajit Pal. Page 35. I do not know the accused nor the Ranjan disease also. On 28/99, I was a pawn shop at the cinema hall Meghana at around 10:30 am. I heard a loud sound, seeing the people running different direction. I started running. The noise which resembled blasting of tire echoed with the cinema hall's premises.
He has a pawn shop
Yes, he is the pawn
in the cinema hall.
cinema hall. And now in the cross, he said, my lord, it is not the fact I stated before the police in any manner. There were a lot of customers at pawn shop. When I noticed the crowd rushing out of the cinema hall, I glanced over and saw the boy lying in the pool of blood. Panic. I also sat with the crowd, keeping my shop. I did not see among who crowd had killed the boy. It's not the fact that I saw the disease on the day of the incident. I was accused of false evidence because I am afraid of the accused. He is a policeman. On that day, police is one empty 39 AM pistol cinema hall and put my signature. Exhibit 1. Exhibit 1. Lord, and cross. The sound was heard resemble bursting of the tire in the cinema hall. I did not witness the incident. Later, the police arrived and called me to the place where the dead body was lying. I could not recollect what they did before the police, as police did not read over the same to me. I have not seen this curtis in the court. Then PW my lord, Ananda Pathak.
Informant.
Yes. On August 23, I was the booking counter Urvasthi Cinema Hall, Golaghat town. I worked there. I saw Arun Kurmi when the police brought him to the cinema hall in connection with the investigation of the case. I lodged an Etahar with the police station in which unknown shot killed another unknown person in the premises of Urvasthi Cinema Hall at around 11 on 28/99. It is the Ezahar lost and exhibit 2 1 is my signature. At the incident, I did not know the person who has shot. Later, I learned that the body boy who died in the incident hailed from our area, Kabaru village. I did not know his name. At the time of incident, I was working in the counter and I heard the sound hum at first. At the first, I thought it was the sound of fast tire bursting. However, upon noticing people in the cinema hall premises running all directions, stepped out, standing on the stair, I saw a person lying on the ground inside the premises, writing in pain. Then the other employee of the cinema hall called out the matter and informed to the police station over phone. I saw the arriving taking now, my lord. Another thing has come, my lord. Now he is saying, my lord, another person has informed. I saw the police arriving and taking away the body which is lying on the incident. Police is the one empty cartridge. The place and so exhibit 3. 3 to 6. 1 and 3 cartridge, 3 number plug. To page 106. I came to know who become the injury. On August 20th of being counter cinema hall Golaghat. The time shot was 11. At the time I heard the loud sound similar to the blasting. I noticed the person who assembled in cinema hall premises started running. I also noticed one boy lying inside the cinema hall premises. He was writing in pain. Then I went upstairs and after discussing the matter with the other staff, contacted the police over phone. Thereafter, police arrived at the cinema hall premises, made an inquiry and took the dead body. Later, I came to know that the injury bodies come to injury. I do not know the intent of accident occur. I know neither deceased nor accused person. Police question me. I have never seen the accused present in the court today. He said he never. Now, Lordship will see PW4 is the Dimbashar Bora whose statement on 27th day of July. On 22/8/99, I was working at Armor at Golaghat Police Station Reserve AK Sahu TSI Golaghat. This one 9 AM boring surface pistol and magazine of the reserve. The number of the said pistol is. First, you kindly note down this pistol matter, page 41. Pistol is 16120,790. Cartridge and also is in connection with the Golaghat PS case number 10. For that, my lord, I like to draw lordship attention on chart, my lord, press chart at page 6. We know. I need to select no. After remand, my lord, now press charge has been came. The chart lordship will see the recharge page is page 6, my lord. Pistol number 1620 or 162 363 901. So this and Caesar, my lord, does not match. Now, page 6.
Where is the fresh charge? Page?
Fresh charge, page 6. That on 29 at 11 in front of the cinema at Golaghat town under the Golaghat committed the murder of 5 posting such that to Ranjannath at 9 AM. So bearing 162 36901. hereby committed the offense under section 302. Secondly, that about the same day, the place of occurrence alleged pistol bearing number 91. Now also different story. Start. Then, my lord, we are back to page 40. Officer Dhanpati Deka was with me. The said pistol was seized and put my signature. Exhibit 4. Put to side था. Pistol to number कोई है ना? आते नहीं क्या मत. That page is temporary. And all the seizure lot will see exhibit 4 97 onward. Seizure list lottery. But that was different.
Second charges were framed on 12/8/2008.
Yeah. Bearing pistol number 1623691. Not my, which has been given as per the portion of page 41. Is and list is my signature, and A.K. Sahu again came to Golaghat Police Reserve in connection with the case and seized 3 9mm boring pistol and 15 rounds of live cartridge magazine, which was under the supervision of Lordship. Kindly remember the name, man. ZZ OK 97. ZZ OK 97. And this, my lord, what FSL has sent, my lord, Lordship will see simultaneously at page. What is 110 नहीं? No, 110. And now Lordship will see the FSL 110. Description of the art. Okay, here it is.
110.
110. Description of the article. That was, it was similar. Place of occurrence of keep. Similar, no? To okay. Lordship will see the FSL gave a report, pistol bearing OK number. And they have this, which is my supervision, ZZ OK 97. Inscribed on the rim of the said cartridge, the numbers of the 3 numbers of pistol magazine 16289
No,
with
this is
a
the first report. This is the first report.
second report to put, second to 9.
First report we have already seen. Because see
Second
the
report.
date.
Itu gimana?
This is 26/8/1999. And the
90.
event was of 28/1999.
Second report also with there, my lord. So one empty cartridge, exhibit 8. So, that lordship will see 109 result for ticket. Using the cartridge, exhibit E2 for out. This is also 99, 109 also. Any care. Up to 9 of 1. Now, lordship, back to page 42. 3 numbers of pistol with magazine are the magazine 162901 along with the empty cartridge with the empty magazine. At the time of seizure article, reserve officers Dhanapati Deka also present. Exhibit 5 seizure list and 5-1 is the mark. The pistol bearing number so and so and pistol bearing number 1623781, the pistol bearing number 1620, and also seen the material exhibit 4. Pistol bearing number 161-20790 on 29 and 99 PSI Orun Kumar Sahu sees 5 numbers of ammunition of 9 AM pistol magazine in the reserve collector that the reserve officer Dhanapati Deka also present. The said ammunition were seized in connection with the Golaghat PS case number ZZOK 97 inscribed in the rim of each of the state ammunition. Exhibit 6 is the seizure list exhibit and signature. The investigation officer 1 diary arms and ammunition issued of the guard police the Golaghat from the period 24 to 99 to 50 to 899 from the my custody. Exhibit 7 is the seizure list. Exhibit 7-1 the second. And page 40. I have seen today in the court is mentioned that the exhibit 5 is of 19/8/99 AM pistol bearing number 162 6901 with 12 rounds of 9 AM live cartridge, 1 magazine. Constable Arun Kurmi. At 10:11 AM, Arun Kurmi returned the same to me, and after receiving the same, I mentioned the registered and A.K. Saharia, the then Superintendent of Police, Material Exhibit 5, did not put his signature there. And Arun Kurmi returned me 12 rounds of ammunition along with the magazine. It has been mentioned. Exhibit 5-1 is the name of the Arun Kurmi. Exhibit 5 is the pistol bearing number 12. So Arun Kurmi put 12. So exhibit 2 have 5 or 5. Now, pilot cross. I know the accused Arun Kurmi. I was previously deposed in the court in connection with the case on 20. I received 19 AM pistol, 12 round of ammunition magazine back from the accused on 28/99.
Okay, will come after 5 minutes.
I put on a photo. So I would accord as for court number 32 or so. Tell you, Carlo. Correct. নাই নাই ডেডবডিৰ লগত কি পাইছে 4 inch of irregular lacerated inverted edge with the blackening of the edge with a little gunpowder in the edge. The track would direction towards the front enter and social bacteria mouth cavity, tearing tongue and wounded the paternal bone in front of his blackening of this incident. Bone weight and pound injury survival by the sense of the opinion. In my opinion, the injuries were antemortem in nature caused by the gunshot and that of the disease occurred due to the shock and hemorrhage resulting from the injuries sustained. Exhibit 9 is the postmortem where so and so cross. From the nature of the injury, I opine that the injury of the gunshot, any other sharp object cannot cause such type of injury. Such type of injury cannot occur due to the falling on the road. Steps pressure. From the experience, I detected that the injury bone gunpowder was not a fact that I did not find the gunpowder over the injury and held that of the disease was not caused to the gunshot. Now, Lordship, will
This PM report, exhibit 9 is which page?
exhibit 9 at page, my lord.
Hmm?
Postmortem report 114 to 120. Was done on, my lord, 20 August 99, Golagat case number so and so, date of the owner so and so, 12:30 as per request. Several condition of the south embodied composed, etc. That body was a young adult of about 18 years, black hair, gas complexion, wound, position and character. Gunshot injury on the back of the neck, upper part, right side of the nape of the neck, wound turns 3 foot 20x, irregular, lacerated, parted edge, the blackening of the edge, little gunpowder in the edge, the track of the wound, section fan, and operative part, my lord, Lordship will see page 118, my lord, muscular bone joint and union system.
I'll write.
Opinion. For opinion more for muscles, bones and This informative factor description, more detailed description of the injury or disease, opinion of the assistant, cause of the death is the cause of the death that is there might not shock and influenza as a result of injuries sustained by disease. 119, it is there.
Falls apart.
Now Lordship will see page 57. Is the PW 10. On 28/9 at and 6/9/99, I was working as a senior scientific officer, so division forensic laboratory, Assam, Guwahati. In that 2 dates, I received 2 steel boxes in connection with the Golaghat PS case number so Golaghat and Superintendent of Police, respectively. Director of the High opened 2 steel boxes of pound so Now, Lottie will, this is the important. One fired 9 mm pistol, which is marked as Exhibit A. One 9 mm pistol, bearing number 161207990. It was issued to me. Number 2. Number 3 9 mm pistol, bearing number with 1 empty magazine marked as Exhibit 2. One 9 mm pistol, bearing number so and so. Itu kak. Then number 5, 1 pistol bearing number 12. Pistol condition 12. Examine exhibit. Now let's turn to page 58. Exhibit 2 is the firearm, which is the serviceable. The test firing wire through exhibit B. Perform the pin forensics on the test of the so wire under the comparison and microscopic wire formed in the dissimilar may be found to be dissimilar. Hence, it might compare an exhibit to which the fire exhibit. Hence, it may be the concluded that exhibit were not fired. Page 58. The test firing were done through exhibit A to B, C to using the cartridges of D2. Firing at the pin impression exhibit 2 are compared with the firing expiration exhibit A, which were rejected by number so and so 23/8/99. The firing pin impression on the test cartridges fired through exhibit A and 2, and exhibit A is the exhibit cartridge case of memo number so and so. We were found to be dissimilar. Is also dissimilar. Dissimilar, the firing gun position impression so and so test certificate fired through exhibit D, bothering the boring pistol number 162091 was found to be similar to that of exhibit A. Exhibit number so and so. Hence, it may be opined that the exhibit fired by exhibit B2. Similar report, director of SL who forwarded the report to the Chief Judicial Magistrate Golaghat Superintendent. Exhibit 2 is in my official report dated so and so is my signature. Now cross-part. I depose the evidence today in connection with the same case. Until box were not received by us, we do not examine fingerprint and thumb impression. Only examine the arms and ammunition and so. That is important, my lord. He did not reach. We did not. Fingerprint did not. Then lordship ammunition and manuscript through the and so from the chief judicial magistrate sought in the following point whether the exhibit mark 1 mark A was fired through exhibit mark B2, whether the mark B is the serviceable. On the superintendent of police so opinion was sought whether the exhibit mark A sent to the FSL by memo number so was found through so. The further a DEF and other point was whether the exhibit marked as DEF were serviceable. On the fire certificate marked, the exhibit A was found dissimilar. He also found, my lord, dissimilar with the pistol marked as exhibit B, A, and C. The finding of the impression, then next page, my lord, 59. On the test certified the field through the exhibit A and C2 and exhibit A were found to be dissimilar. Firearm print impression test clarifies the fire through the exhibit 2 boring pistol bearing number 1623690 was found to be similar to that of exhibit A certificate case of Swanso. It cannot be said that how long the arms of the ammunition were found to be fired in a specified long run. There is no time-bound factor whether the time is required to be kept usage of the ammunition tag. It is not a fact that no steel boxes then had been sent to the received by me for the purpose of examining. Then lost to turn to the next page, 62 to cross next. Itu kia. He 7. Now PW 11 mile. His name is Robin Chandra Das, was deposed on 27/7/12 at page 60. On 2010-2009, I was working as SI of police in Golaghat PS. On that day, officer in charge of PS entrusted me with the charge of the investigation of Golaghat PS case number 3299. Earlier investigation, Arun Kumar Sahu was promoted from sub-inspector to second officer of the PS. After pursuing the city minutely, I satisfied that the investigation has almost completed. I communicated the officer of the Deputy Commissioner Golaghat regarding the collection of the prosecution sanction, which was yet to be obtained. But that part is not, I did not find obtained. Concerned dealing assistant informed me that the arms belong to the government. Prosecution sanction was not, he said, meaning thereby no sanction was obtained. When I communicated the SP regarding the issue, he also stated that since the open was authorized one, no prosecution was required. Then I referred the matter to the OCPS to prepare the progress report on 27/02. I collected the copy of the statement Babul Datta in the Honorable Court in connection with the case. On 3/9/23, receiving the approval from the Additional Superintendent of Police regarding the commission of the offence 302 read with section 27, I filed the charge sheet against the Constable Arun Kurmi under the aforesaid sections of law itself. I found sufficient intimating material. Exhibit 10 is the signature, then cross part. In the previous IO, Arun Kumar Sahu was transferred. He OC entrusted me the charge of the investigation. So Arun Kumar Sahu was promoted and posted the same police station. He was near to me. Previous IO had almost completed the investigation, except collecting prosecution sanction. I was not required to conduct further investigation. Only prosecution sanction was have to be collected by me. It is not the fact that I filed the charge sheet as per the directions of Arun Kumar Sahu. I did not investigate the landlordship will see 13. Then time it was my lord 64 CRPC. Then question were put, my lord. I was being adduced the evidence against you on the 29th. I keep the Ranjan in front of so. Question number 2. Do you have to say anything regarding the answer says no. Question number 2. Will adduce the evidence in defense? I don't. It did not. The above examination was taken in my presence, sharing Patel's content full and true account of the statement of the and new one lordship will see at page 65. The new one, my lord, question number 1. Samantha has deposed that it is Ranjanath was his friend at around 1-2 p.m. on 23rd. Little later, Ranjanath entered the cinema hall. He heard the sound of gunshot. The people started running different directions, sentencing so and so, injuring the unknown was about the Ranjan. He told him that he was lying. He was lying inside the cinema hall compound and then going there. He saw the Ranjan was lying down inside the small compound covered in blood. Do you have to say anything? Answer. I want to say that I did not know Ranjan got covered in blood. I did not know
Why
him.
address 2 questions separately? In the first one, only 1 question on 313. Is it 313?
Maybe 313.
63?
313. That's to
No, the
364, my lord. Human 65.
both appears to be under the same. Why separately?
Maybe after one, maybe earlier, and second is
Part one, 7. One is 12, 9, 30.
13, 12, 9,
Okay.
30.
So that
Maybe after remand, my lord, page 65. 11 to 7 for a little Ranjan. About I told 66. He told him that a person was lying inside the cinema hall compound and then going there. He saw the Ranjan lying on the ground inside the cinema hall. Answer. I want to say that I did not know how Ranjan got covered in blood. I did not know him. Question number 2, page 66. Ajit Pal has deposed that on 22/28/19, while he was in pawn shop outside the cinema hall, Bhaganagot 31, there was a sound gunshot. Hearing the sound, people run here and there. Do you have to say anything? I have nothing to say in this regard. Then question number 3. PW3 Aditya Bhattakur has deposed that on August 7th, lodged an Palagat regarding a shooting incident in which unknown person shoot and kill another person inside the Woodbury Cinema Hall premises at 11 a.m. on the same day. Do you have to say anything? I have
No,
nothing
no,
to.
those may not be read. He has not
Yes, ma'am.
accepted
The
anything.
question was there. Not now, Lordship will see. Pune. So now Lordship will see the impugned judgment. Past judgment, my lord, that is there in page 75. That has been set aside by the Honorable Court, my lord. So we are going into the fresh one. It starts from page 79. Right. Your lordship will see page 79. It is the inner page of 2. May I read, my lord?
Yes.
Prosecution case in.
Not required. The judgment will not read.
No, my lord. Para 2 is needed. That. Lordship will see para 2. 9 mm ZZ okay. Para 2, the OC police station on the receipt of the written Ejahat, so and so the ticket seller at the state cinema hall registered the case of the Golaghat under number so and so. During the investigation, police seized one empty Curtis 9 AM, which found within written as 9 AM ZZ okay. Okay, 97. This was the fault. Now lordship has to examine the body, what was the number and what was sent for it. FSL also did not call. And para 2 of the judgment says about the pistol number, my lord. There is another thing, my lord. Roman 1, 2, 3, 4, my lord. ZZ okay. Number 5 is the 15 run of 9 AM ammunition live on the bottom, which is written as 9 AM ZZ okay 97. It is not the case, my lord, that FSL has said this particular gun has shot. Maybe similar, maybe because all police gun is the similar.
No, the FSL has said exhibit A and exhibit B1 are matching.
Armed. But fired from this, it is not there. Lot people see, my lord, which gun was issued to and what FSL has said.
What is the evidence? Which gun was issued to you?
My lord, teaser list reveals, my lord, human 97. Na?
No, the armorer who issues the gun from the reserve. What is the evidence that which gun was
My
issued?
lord, PW5.
What-
PW5,
He said which gun was issued to you?
my lord. Untu 104. So more pura. But before coming to that, lordship will see what
43 years.
106.
43 years. Yes, 43 years.
Action if the state material exhibit 5 then on 1999, 9 mm pistol bearing number so and so, 162-36901 with 12 rounds of 9 mm live 30 Gs and 1 magazine were issued to constable number 64 Arun Purmi, who is the appellant here.
Just a minute.
Two sets. Apart to 104. Before coming to that,
Just a minute. 1999.
he returned for 60. One zero four, na? 106. Oh. So which the return code? PW5 is the bottom of the life cut is the state article to the another officer the on the Arun Kurmi again came to the Kotaka
But that was returned.
Yes,
That
return.
was but I'll
My lord will see that.
return
No, no.
unused.
Return unused, and see the cross part.
43.
Page 43.
Yes,
I know accused Arun Kurmi, he's the appellant.
yes,
I had previously deposed in court in connection with this case. On 1999,
One.
I received one 9mm pistol and 12 rounds of ammunition with a magazine back from the accused.
yes.
On 28, I received 5 numbers of pistol along with a pistol number so and so. This 901 was issued to appellant.
Appellant.
On 1998, a pistol bearing 93 was issued in the name of Bhadreshwar Bora. And I received the bag, the pistol, live cartridges and magazine issued to Arun Kurmi should be, were returned to me unused.
The time factor, that 1 p.m.
1 p.m. unused.
Before to be clarified, my lord, lordship kindly turn to page 106. That was been recovered.
Incident was at around 11 o'clock on 28.
28, 20.
He returns the arms ammunition at 1 o'clock. Everything. And and what is we have to really examine is the forensic expert.
Yes.
Come to
Evidence of PW 10, your lord.
10, come to page 57. Or you better to come to the report itself, Exhibit 8. Exhibit 8. Exhibit 8 is at page,
Lordship to clarify, my lord, lordship has to see, my lord, 106. What was the
Exhibit 8. Come
recovered
to
from the place of
110. Come to 110,
0?
yes.
Artist number okay, which is marked for exhibit. To contradict.
No, come to both 109 also.
Yes.
Exhibit 10.
Neither, my lord, the piece from the place of occurrence has not been sent for FSL. I didn't find that. Your lordship will see place of occurrence.
No,
10.
you come to
Serial number 2, your lord.
109. Come to 109, madam.
Yes. serial
Last
number
line. Hence, it may be opined that Exhibit A was fired by Exhibit B2.
2. Yes.
Let us see what is Exhibit A.
Exhibit A.
A.
Pistol,
Pistol.
page,
Exhibit A.
One,
Yes,
one.
Exhibit A is on the next page.
1110.
Exhibit A is a 9mm cartridge.
Hmm.
Okay. It is fired by Exhibit B2. B2 is at page 11109.
Yes.
B2, what is B2?
B2.
It is 901. B2 is 901,
It's
number
a
901.
pistol, lordship.
901.
Yes, my lord.
901 was issued to the
Accused
Accused.
appellant, which is received by the armorer at 1 p.m. So the armorer is not an expert, your lordship. After the occurrence, if after commission of the crime, it was returned to the armory, your lordship. It was returned, in fact, indeed.
Mr. Borbhaiya,
Well-
the pistol which was issued to you is 901.
Yes.
901, and this examination says that the bullet which was fired appears to be from 901.
Similar. But bullet, my lord, have been received.
Now, what bullet has been received, that's a different matter.
Yes, man. That I'm coming, man. Now, lordship will see
And what is also more,
106 piece in man. That is the recovered from the place of occurrence. Empty cartridge number bottom of which found written 9M 2Z OK. 97. And now, my lord, the place of occurrence, and now, my lord, FSL does not say so. It was been sent or not. It is been, my lord, only okay.
Where are you reading?
My lord, page 106 is the seizure list from the spot.
106.
Check. Description of the cartridge. ITSI AK Sahu Golaga do hereby seize the following descriptive article today on it at on a reference the found lying with the place of occurrence material exhibit in presence of undersigned witness. Name of my lord. Name of description of the cartridge. One empty cartridge 9 mm bottom found written 9 mm to that K. And now Lordship will see what has said. FSR sent something different. To that okay never sent.
What is FSL?
FSL description Lordship will see 110. One fired as 9 AM pistol cartridge okay, which is marked as exhibit A. And pistol number 16079. 862 number tag. And at what? যদি আমাকে একটু 97 901 at 950 NTR 91 because আমার কোন 91 আর ফ্রেম কি হবে মানে 901 itu pas 901 apa code
Where is the FSL expert?
he is
Yes,
my
50
lord
57.
PW
57.
10
57.
my lord PW 10 start from page 57 and 59 wow much
Okay. Okay.
and this does not match with the place of occurrence 106 does not. One fired 9 mm pistol, cartridge number OK, marked as exhibit A. This and 106 doesn't match. What I understand from the going through this, my lord, the bullet which has been recovered with the dead body, it was never sent for it because number doesn't.
The bullet was not recovered. Only the empty cell was recovered.
Yes, it's empty.
But
Used one.
we are also on the aspect that if you closely examine the post-mortem report, the bullet was not found inside the body.
Yes.
So that means the body had bullet had pierced the body and had gone out. But that bullet which had hit the deceased was not recovered.
Recovered, my lord, 106.
Let us see.
106, my lord, Caesar. It has been recovered.
That is, that is the empty cartridge, not the
Yes,
bullet.
it's empty.
Not the bullet.
Empty, empty.
Not the bullet.
Not bullet.
There are
backside.
two parts.
Back, yes.
One goes from the pistol, one remains.
Yes.
The empty cartridge has been recovered. The bullet which has
Already entered.
pierced through the body because it come to the PM report.
Yes, I have gone through it.
Come to the PM report. 1-1.
1-4.
115.
No. Come to 118. 118, last page, last line, injury. 118.
No bullet was found inside the body.
Inside the body. That means the bullet had pierced
Gone.
through the body and gone outside. It should have been recovered.
That has not been. But remaining part, my lord, after using the bullet,
That the empty cell is there. That
empty
is
cell
not.
does not match.
You say that the empty cell which was recovered from the site,
Yes.
place of occurrence,
It was not
and described in the seizure list
106.
is not matching with the cell which has been sent for examination. 2Z is not written. 2Z OK 97 is not written.
Not-
Only OK is written.
Only. Okay. And a fingerprint also not there, man. Had it been a fingerprint, it would have been. Place of occurrence got 2Z OK 97. And FSL sent, my lord.
Okay, we'll come back at 2 o'clock. You formulate your arguments. We have understood your case. And then we'll hear, madam. We'll try to
Or
finish
lord,
up.
can it be like this? Lord, to keep it as the partner
No,
matter?
we have already have 2 to 3 partners. We are going to complete this. We have already completed. You
Yes,
just
yes, my
formulate
lord.
your
Another
points.
quote I got a picture through, my lord, that I'll take it.
You have completed, then you can make a
Yes, yes.
short reply.
Yes. To me, my lord, that has been given, my lord. Lordship, kindly have a look, para, my lord, of the impugned judgment. Seventeen. Inner page, my lord, 8, my lord, para 17 of the judgment, my lord.
What is there?
It has been said like this, my lord, from the scene exhibit 5, one of the pistol bearing number 12, so with 12 number of cartridge and one magazine issued to the accused. So state constable accused named in the so on they returned on 28/99 at 1 p.m. Is the name of the accused Uran Karmi recorded in the state register on the date of so 19 is the with the magazine which were found to be issued in the name of state exhibit 5 and signature of the Arun Kurmi dated is showing that the acknowledgement of the receipt against the state pistol that we have received it. Then Lordship kindly turn to the para 19 of the judgment, my lord. The PW seeks the constable to depose in the evidence that they accompanied with the accused 64 Kurmi went to the cinema hall to enjoy the cinema hall, reached there 9:30 p.m. on seeing the gathering. PW was without informing the Arun Kurmi. When he got the cross at the gate of the cinema hall, he heard the sound dham, and in seeing the gathering running so and so. Then Lordship kindly see the important part is the next parameter. He has cross-examined the prosecution with the reference to the statement under section 161 during the investigation stage, gave the statement 164 on oath. The court has the learned provisional magistrate Golaghat exhibit 6 with the state statement recorded 164 on the oath, exhibit 81 she are the signature. The plea of the Babul Datta is that he made the statement before the investigation as per the instruction of the then superintendent of police and additional SP of Golaghat, but did not state that he made the statement by the before the court. Now, para 20 15, my lord, of the impugned judgment. PW7 Arunde deposed that in the evidence dated 28/19, he was in the shop dated the vicinity of the compound of the cinema hall, separated with the road between the shop and the compound of the cinema hall party put signature exhibitory. The seizure exhibitory is the signature. According to the evidence petition, police did not seize anything in front of that. Your lordship will see the deposition at page 52 also. Did not seize anything. Now, the core issue before the trial court was there, my lord. I do not know how the learned court below has passed the impine order. Firstly, my lord, I like to like to apprise this honorable court, my lord. Firstly, there is no any intention, my lord. Why shall I kill or why somebody will kill somebody? No intention has been reflected anywhere, nor, my lord, there is any antecedent that I was involved in criminal offense or any. That is not there in the judgment. That apart, my lord, PW4, my lord, he has stated, page 4. And 43, my lord, in the cross also he said, my lord, page 43 and 45, whatever arm was issued to me, that I have returned back. Now, lordship will see there is no FSL report also. To come to the specific logical conclusion, my lord, some FSL is needed, which that. And my lord, there is no recovery of the bullet, man. If the bullet is not recovered, my lord, the question of saying this thing cannot arise, man. There has to be some recovery. Bullet was not there, or should have seen, man. And moreover, my lord, the vital point was that, my lord, the accused appellant is the government employee. And 197 does not bar, my lord, that you cannot take sanction. 197 was not complied with. Rather, my lord, he said, my lord, since it was been issued, government gun, that's why sanction is not required. That cannot be, my sanction is a must. And that apart, my lord. And place
But
of
what is the part of in discharge of your duties?
duty, my lord,
You were in civil dress.
no, my lord, on that day I was on off.
Off. You
Off.
were carrying a gun.
My
If-
lord,
if the
because, my
allegation-
lord, I
let us-
UTP I have to produce.
Now, let us be on the assumption, let us proceed with the assumption that you were off duty and
I
but
was
still
in-
you had a gun and you shot somebody. Is it a part of discharge of your duties? Well, when will 197 come into operation?
That is, my lord, not
No,
clear.
If you are in duty, then also you do something which is not legal, not
Legal.
permitted by
That,
law.
my lord, in that case.
Then the
no.
question may come whether it is a part of discharge of
duty
duties
or
or
not.
not. Here, you are off duty, but
Off
you are
duty.
still, the allegation is that you had a gun, you shot somebody.
Yes.
Whether
Okay.
that can be held, perhaps 197 may not be a
Yes, my lord.
very
that,
strong defense
that
in this
keeping
case.
aside, my that keeping aside, my the core issue before your lordship is that, my lord, since 2013 I am behind the bar as on date. And I filed an IA also, my lord, that your lordship said the entire matter will be heard. That's why I did not insist on that. IA is,
2013, you were arrested.
yes, since the date of judgment, I am behind the
No,
bar.
judgment
Because, my
is
lord,
dated
what
what?
happened is the fact is
Judgment
that
is dated what?
judgment dated, my lord, lordship will see was in, it was delivered. Dated, judgment was 8/11/13.
The second judgment?
Yes,
After conviction?
yes, second one.
Okay.
The impine which is your lordship. Since then, I'm behind the bar. And coincidentally, my lord, one of my junior fellow was traveling in the bus, my lord. His relative requested me to my colleague, my lord. Then only we came to file this along with the IO. So that is not the subject matter. And lordship will see very vital thing is that, my lord, teacher list 102, page 102.
102.
102, teacher list, my lord.
There are two scissor lists.
Yes, 102 be seen. Place of occurrence 106. To police of Parole. 106. And place of occurrence is, my lord, 106. That has not been gone through that. Something different. Page 106, my lord. The empty cut is on the bottom of which it is written 9 mm, 2Z, OK 9.
Why it is two separate empty curtains?
Because, my lord, it was seized from the particular place and police from the police.
Empty 106.
106. That has not gone to the effect. Nor bullet was recovered. And nobody in the statement said, my lord, that I shoot the gun. Only basing on the presumption, I am behind the bar. Almost 12.
This is not the subject matter of the FSL examination.
Yes, that
What
was not
FSL has examined the bullet is only OK is written.
Yes,
Not this 2Z OK 97.
no, it is not, my lord. Page 110, lord. You will see other thing. Okay, was there. In the bullet, my lord, there is to be marked. And the imping does not reflect, my lord, the cause and reason for conviction. It seems to be, my lord, either it is a case of a circumstantial evidence or basing on the presumption that can. How he has reached the conclusion convicting me life. That cannot be. Over and above, my lord, for killing 302 must be some, my lord, either provocation or by the intention. Or I have a bad conduct. It is not. Because, my lord, the case has gone back. Maybe, my lord, somebody has written or from the paper publication. Then, my lord, earlier judgment totally differ from this. Anyway, my lord, that has been said, we cannot rely on that. The basic principle, my lord, relating to the corroboration and pinpoint, my lord, specific is not there. Nobody said, my lord, that the particular person has to come. And one person said, my lord, who is the seizure witness, my lord, page 52. He said, my lord, nothing has been seized in presence of page 50. Mutiana paper. Mark it. 52, my lord. Lordship, kindly have a look, my lord, for a moment. Paper book. Oh. There is a wide contradiction. And he said also, my lord, I do not know the document. Maybe that occasion, my lord, since the matter has come back from the Honorable High Court, my lord, they need to fortify without authenticated document or evidence or otherwise anything. All these things are, my lord, which is the prime requirement of 302. It is not. No intention, nothing, my lord. So, in view of that, my lord, I pray before your lordship, my lord, the case to grant me at liberty, my lord.
Any decisions you are relying upon?
Relying right now, my lord, I do not have. I'll supply tomorrow, my lord, along with my argument. Let them complete my.
Yes, madam.
Lordship, I'll be relying on the evidence of PW1, who is who happens to be with the deceased. Lordship, when the occurrence taken place, not with the deceased, but he went with the deceased to the cinema hall, my lord. Shamanto Bora, the friend of the deceased, your lordship.
Yes.
Then the evidence of the armorer depend or PW4, your lordship.
Shamanto is PW1.
Shamanto is PW1, then PW4, my lord.
PW4
Deveshwar Bora.
is Deveshwar Bora, armorer.
Lordship. And forensic report. Lordship, as per the evidence of PW1, at around 11 a.m. to 12 a.m., your lordship, the accused, the deceased went with PW1 in order to see the movie, my lord.
Yes.
Evidence of PW1 has not waited your lordship. Page 32. Lordship, may kindly note, second line, page 32, around 11 p.m. to 12 noon on 28/99, he died in a cinema hall at Banganakwa, Golaghat. He was shot dead on a day of incident. I accompanied Ranjan Nath to a cinema hall to watch a movie. On that day, as the classes were dismissed early due to the demise of a college staff, Ranjan Nath and I rode a bicycle first to Chitrolekha Cinema Hall and after that to the cinema hall at Banganakwa. After asking me to keep an eye on his bicycle parked by the roadside, Ranjan Nath entered the cinema hall. He came out once to tell me to wait, then went back inside. After a little while, I heard a sound of a gunshot. People started running in different directions and the shop started closing. I started looking for Ranjan. When I asked an unknown passersby that I could not locate my companion Ranjan, he told me to have a look at a boy who was lying inside the cinema hall's compound. And going there, I saw Ranjan lying prostrate on the ground inside the cinema hall's compound. He was covered with blood. Being helpless, I rushed to the Ranjan's house at Bongaon, and on the way, I informed the cooperative shop by the side of the road of the incident. Thereafter, I, along with Ranjan's uncle, went to Golaghat police station, but did not find Ranjan there. Then Ranjan's uncle and I went to civil hospital and found Ranjan's dead body covered with a white cloth. I did not know who shot dead Ranjan, police patient. Lordship, then the other person who accompanied the accused person, my lord,
Babul.
Babul.
PW1 has there is nothing
No,
incriminating.
regarding the time factor, I'll be relying on because 10 a.m. The second line, PW1, my lord. The occurrence around 11 p.m. to 12 noon. He said he died. So the occurrence might have taken place prior to that. You know. Lordship, then evidence of PW4, my lord. PW4 is the armor area, Lordship. At page 43.
Yes.
At what time accused person returned, Lordship, at 1 p.m. on 28/99. 28/99 is the date of occurrence. And at around 10 to 11, the occurrence had taken place. 1 p.m. after that occurrence, my lord, Arun Kurmi returned the same to me. And after receiving the same, I mentioned it in register number so and so. On 22/8/99, G. A.K. Sahori, the then Superintendent inspected material expert, put his signature there. So, Lordship, on Lordship, prior to that, I'll be relying on first line. It was mentioned in the set material exhibit 5 that on 19/8/1901, 9mm pistol bearing number 162-36901. Your Lordship, kindly mark that number. With 12 rounds of 9mm live cartridges and 1 magazine were issued to Constable number 64, Arun Kurmi. So it was issued on 19/8/99, and as part of forensic report, this weapon was very much involved at the time of Lordship. It was Lordship. In the forensic report, the number has been mentioned, and it tells this number, my lord. 162-36901. My lord, I'll be relying on, my lord. Page number 110. Lordship, page 109, serial number 2, 19 ml brown pistol number 162 36901. Lordship, it tallies the number at page 43. The arm which was handed over to the accused person. With one empty magazine which is marked as exhibit B. Lordship, and as per evidence of the expert, my lord, PW10, scientific officer, your lordship may kindly have a look. This evidence, PW10. Lordship, page 58, second paragraph, last 4 lines. Has the lordship got it?
Yes, sir.
Page 58, second paragraph, last 4 lines. The line starts like that, my lord. The firing pin impression on the test cut is fired through exhibit P, that is brown pistol having number 1623691 was found to be similar to that of exhibit A, that is exhibit 30 case of memo number so and so. Hence, it may be opined that exhibit A was fired by exhibit B. And there is nothing to disbelieve the evidence of expert, your lordship. It has no personal enmity or interest to the case,
But what about the description of the cartridge? Empty shell.
my lord.
Here only OK is written,
My lord,
and in the seizure, the 99 and 2Z,
my lord.
those are not there. 2Z OK 97, 99, 97 or something.
Lordship, another factor, lordship, that in 3-1 plea statement, no plea has been taken, that he did not use those weapons. Well, nothing has been given, nothing has been stated by the accused
He has
person, my lord.
denied.
Lordship,
Yes,
question
denied.
number 8, lordship, may kindly have a look. Question
Page.
number 8,
Page.
lordship.
Question number
Question number 7,
7, yes, at page 67.
nothing is there, no answer. Let's see the original also.
Devastator will also report. No, this question does not have any implication also. Devastator has a depository, numbers were seized.
Yes,
What is the implication? There is no implication. This is not an allegation.
that is there. But no plea has been taken by him in 3-1 plea. That he has
Regarding-
not used it, or it doesn't belong to him. Right?
Not is
Doesn't belong to
required.
the lordship, the weapon which has been allotted to him by the armorer.
No, is it a denial required of if
May not
is-
be, my
is-
lord.
will a lack of denial amount to a proof beyond all reasonable doubt?
May not be. Another factor, your lordship, my learned friend has taken a plea that there's no motive. Motive is not there. But in all the cases, motive may not be the essential factor, my lord. I'll be relying on one of the judges regarding motive part.
You said a
Surendra Singh versus state, my lord, Union Territory of Chandigarh.
citation? Name?
Surinder Singh was the state union territory. Regarding number 55. It's reported in my lord. 2021, 20 SCC 24.
Which paragraph? What is the position?
Lordship, para 23. This court has time and again ruled that in case the prosecution is not able to discover an impelling motive that could not reflect upon the credibility of a witness proved to be a reliable eyewitnesses, evidence as to motive would no doubt go a long way in cases wholly dependent on circumstantial evidence. Such evidence would form one of the links in a chain of circumstantial evidence in such a case. But that would not be so in cases where there are eyewitnesses of credibility. Though even in such cases, if a motive is properly proved, such proof would strengthen the prosecution case and fortify the court in its ultimate conclusion. But that does not mean that if motive is not established, the evidence of an eyewitness, it's not necessary in our case. We are thus of the considered opinion that was motive is unfailingly a crucial factor and is a substantial aid for evincing the commission of an offense. But the absence thereof is, however, not such a quintessential components which can be construed as fatal to the case of a prosecution, especially when all of other factors point towards the guilt of the accused and testaments of eyewitnesses to the occurrence of malfeasance are on record. Applying these broad parameters to the facts and circumstances case in hand, we find the plea raised by the appellant devoid of any merit. Prosecution, Lordship, but in our case, there is no eyewitness.
Eyewitness.
And Lordship, that presence of the accused person, that his colleague dropped him in the cinema hall. Accused person is dropped in the cinema hall, my lord. And Lordship, there is no plea of alibi to that effect that he was not there, my nothing as such. His presence is there, although directly not proved, but Lordship, from the evidence of his colleague.
But why there weren't a single eyewitness? A person has been shot in presence of so many people inside a crowded cinema hall compound, broad daylight. Not a single eyewitness. Why?
Because the Lordship, when the occurrence had taken place, the people ran either.
Somebody must have. How is it possible that in so much rush, one person takes?
And as my learned friend has said, my lord, he was wearing civil clothes. He was not in uniform.
Nonetheless, you are not required to be in. If somebody is shot, you take out a gun or pistol and aims, shoots, and there is not a single eyewitness. Why? Broad daylight.
But your lordship, the weapon of offense, my lord, used by the accused person was proved by a forensic expert. His report.
Now you have to connect that this weapon was used for commission of the offense.
And who else, your lordship? It was handed over by the accused person at 1 p.m.
Now,
and it was.
If you go by that, the handing over was along with all the bullets which were unused.
No, that is, that
If you
opinion,
could take the evidence, you have to take the evidence as a whole.
that as a
you-
whole, but why,
you
why
see,
to,
At 1 p.m. on so-and-so, Arun Kurmi returned the same to me after receiving the same I mentioned in the register. And put his, returned me the 12 rounds of ammunition along with a magazine.
he said unused
Unused.
ammunition. But your lordship, why to disbelieve the evidence of an expert matter who said
No, expert, then you believe it. Where is the cartridge number?
the
Then
lordship may take it
you
as a left
believe-
of the
believe-
prosecuted
then-
case.
It cannot be to the convenience of yours and to the inconvenience of the other. Expert has no reason to make a false statement, but he has not even seen that this cartridge sand was the cartridge found in the place of occurrence.
Apart from that, I don't find any other material. The prosecution case. If lordship permits, then I can,
Why don't you concentrate on Bimal Datta?
Bimal.com, I know.
Perhaps he is the only saving grace at
That's
page
fine is,
47.
page 40.
47. In spite of he being declared hostile,
Yes.
see what he has said in the cross.
I was relying on his evidence only.
Hmm.
Second line, on that day, accused Arun Kurmi and I went to the cinema hall at Banganakwa to watch a movie. Page 47.
Yes.
We reached the cinema hall at about 9:30, 10 a.m. Noticing a large crowd, I did not watch the movie and left the hall premises in a run without informing the accused.
You
Arun
come to
Kurmi.
the cross by the
Yes,
prosecution.
prosecution. Okay. On Friday, August 20, 1999, I was in the police reserve. That day, I was not allotted duty and was in the barracks. Arun Kurmi was in another barrack. Around 10 a.m., Arun Kurmi, Bhatteswar and I were drinking tea at the hotel in front of our reserve. We discussed about a movie to be screened at a cinema hall in the town. Then Arun Kurmi, Bhatteswar and I boarded the mini truck used for transporting accused persons from the reserve to Horupatar, and we alighted near the treasury office. Bhatteswar left alone to fetch some clothes from the town. Arun Kurmi and I walked to Bata Point and then took a rickshaw to the cinema hall at Banganakwa to watch the morning show. Tickets were being sold for the morning show, and a lot of people had gathered there. I forgot the name of the movie. In a courtyard in front of the cinema hall, both of us contributed money to purchase our tickets, and then I proceeded to the ticket counter where first-class tickets were being sold. A lot of people gathered there. Arun Kurmi was waiting in a corner. Suddenly, I noticed that the people assembled in the cinema hall premises kept looking at Arun with curiosity. Then I turned my head and saw a pistol in Arun's hand. So it was there. Lordship.
Where you pointed out,
Yes. Lordship.
and then there
Yes.
there is some more.
Yes. As I noticed him taking out a pistol in the crowd, I left without purchasing a ticket and moved towards the road. When there was still some distance left to reach the road, I noticed Arun following me with a pistol in hand. Just at that moment, there was the sound of a gunshot. The people gathered there fled from the spot hurriedly. The fired bullet hit a boy standing about 15 feet away from me. The boy fell down and there was bleeding from his mouth. Then I fled from the crowd and proceeding through the market, boarded a rickshaw in front of the jail and left for the reserve. I saw Arun leaving the hall at a run and then heading down the straight road from the kerosene depot Tiniali, a junction of 3 roads, towards the police station. While I was
Next
moving,
para.
while we were proceeding from the hall of the reserve, I asked Arun, why did you take out a pistol in the hall? He did not
He did not
reply.
reply. Thereafter,
I asked him,
you are now.
again, you are now short of 1 round of ammunition. How will you manage? He replied, I will manage it. Don't mention it to anybody else. So, my lord, I think the cross part
Let us see his magistrate statement. This person,
164.
yes, he said that I made statement before the magistrate
Apple.
exhibit 8.
111. Here's one. I know, page 112. I know Police Constable Arun Kurmi. He and I worked together in the Golaghat Police Reserve. Around 10 a.m. on 28/19/99, Arun Kurmi, Bhatteswar and I, dressed in civilian clothes, came towards Golaghat town boarding a vehicle meant for carrying UTP as we were off duty then. We got off the vehicle near the treasury office in Golaghat. Broadressor left saying he would buy some clothes. Arun Kurmi and I decided to watch a movie and headed to the cinema hall near Beganakwa, Golaghat. Since it was 10:30 a.m., the ticket counter was open and tickets were being sold for the movie. As it was a Friday, there was a large crowd outside the hall as a new movie would be screened. I waited in line with cash to buy tickets. Arun Kurmi was waiting in a corner of cinema hall. At that time, Arun Kurmi was dressed in civilian clothes and carrying a pistol, which drew the attention of the people around him. When I accompanied him, I did not notice him carrying a pistol. Upon noticing the pistol in his hand, and while I was waiting for in line, I promptly excited to queue and sought to leave the premises, leaving him behind. Arun Kurmi also left the place following me. At that moment, I heard a gunshot. The boy who was hit by a bullet fell down on the ground. I fled the scene out of fear. He too ran away from the place following me. Later, I came across Arun Kurmi near the police reserve. I scolded him as to why he had carried the pistol with him. We hurriedly left for reserve. He did not tell me anything about the incident, moved to his room. Before leaving for his room, he said that he would arrange replacement for the fire bullets. I do not know as to how it's done. So, Lordship, it corroborates evidence in the cross-examination part of the particular witness in the book. Sorry, Your Lordship, I overlooked it, reading it hurried.
Okay, we'll have to rise.
Tomorrow, my lord.
Lordship will conclude, my lord, because only one judgment, my lord, I rely, my lord, that your lordship will see.
You have concluded otherwise.
If I get to the citation,
You can give it to our court master tomorrow. Then we'll close this.
Yes, my lord, one judgment, my lord, that your lordship is relating to the expert evidence, my lord. Murari Lal, lordship kindly note down, Murari Lal versus State of MP, 1980, 1 SCC, page 704. It will be very dangerous and fatal, my relying
may not
on
always be, my lord.
Murari
relying
Lal.
Murari Lal versus State of MP, 1980, 1 SCC, page
704
704.
paragraph.
Paragraph, my lord, Mr. From the mobile, it is very difficult, my lord. Anyway, I'll get it print tomorrow, my lord. I'll supply it. It relates to the Evidence Act also 114 and 45, 46 also. How it is to be taken into account. And that apart, my lord, just now, my lord, 164 statement, page 50, crossed by the accused is totally nullified. Page 50, just now my learned friend has read, my lord, 164 statement. That has been nullified by page 50 in cross-examination by himself, my though he was declared hostile.
Then what?
Lordship will see. Arun Kurmi, I came from the reserve and bathing the van transport. I got off the van town and walked to the cinema hall. Investigation officer recorded the statement in respect to additional SP. Question me in this connection. I made a statement before the investigation officer before being tortured by SP and additional SP for the sake of service. I cannot recollect what I have stated before the investigation on that day, as I made statement under the influence of the officer. I cannot recall the exact statement I made before the investigation. During my earlier deposition in the court, I did not state what I had stated to the police.
Not fully demolished.
It is not a fact. I did not hear the sound.
Not fully demolished. It's there.
But he said, my lord, he under the duress or under the if the cross is taken into account. He himself saying, man, in the court also, in the police. Anyway, my lord, I'll supply judgment tomorrow, copy, my lord, only. Lordship
So we'll close this then.
Yes.
Heard Sri J. Barbhuya, and then counsel for the appellant. Also heard B. Bhuya. Hearing is concluded. Judgment is reserved.
We'll supply tomorrow, my lord, only copy of the
Yes, and mark the paragraphs.
Yes,
3 o'clock we'll sit.
Tata Ahibad.
In the instant case, no such extraordinary circumstances have been able to be made out according to writ petition stands dismissed. It is however made clear that the penalty order should not come into the way at the time of consideration for conferring any service benefits to the petitioner.
Apply.
In view of the above, court does not find any merit in this writ petition according to the same stands dismissed.
Item 13, Domboru CPO.
In view of the fact that this court has not found any fault in the impugned order of rejection of the appeal, the other aspect of the challenge is not liable to be gone into. However, in the interest of justice on consideration, even the second ground of challenge is not legally tenable. Mere acquittal in a criminal case would not automatically lead to holding a delinquent to be free of any charge in the corresponding disciplinary proceeding. It is right that the standard of proof in a criminal case is wholly different from that of the disciplinary proceeding, as in a criminal case, charges are required to be proved beyond all reasonable doubt, whereas in a disciplinary proceeding, the standard is on preponderance of probabilities. In view of the above, the court does not find any merit in this petition. Accordingly, the same still dismissed.
14 Domburu CPM.
Writ petition is dismissed.
May I please your lordship, I beg to mention item 4. Lordship, we have taken the consent from the other side. My senior, Mr. J. Roy, is out of state. Kindly list after 1 week.
20 matter, madam. Today there may be some difficulty, otherwise next week. On a request made on behalf of the made on behalf of Sri J. Roy, Learned Senior Counsel for the petitioner, matter is adjourned by a week.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 2. This matter, Mr. R. Mozumdar is appearing. He is having some personal difficulties. Matter
19 matter cannot adjourn like this. Yes, when?
any day.
Okay.
Within-
On a prayer made on behalf of the petitioner, matter is adjourned to be listed on Tuesday next.
Lord.
Give the date, huh?
Lordship, I would also like to mention item number 6, 7, 8, 8 on his behalf. Lord.
6, 7, 8. Okay,
sir.
6, 7, 8. On a request made on behalf of Sri R. Mozumdar, Learned Counsel for the applicant, matters are adjourned to be listed on Wednesday next.
Lord. Much.
Item 1.
My lord, here the petitioner was removed from the service of the CISF from the post of the Havildar,
Which organization?
Central Industrial Security.
CISF.
Lord.
Central
CIS.
Industrial Security Force. Okay.
So rule may be issued and we fix for hearing.
No, it's for disposal.
Lordship.
It's for disposal. 18 matter, we are not going to issue rule and fix for hearing. We are hearing today itself.
Then Lordship, I am not feeling well today. It may be taken.
Okay, we can have it any other day. Tuesday next.
Tuesday I will be out of it.
And then Wednesday. Wednesday.
Yeah. Nine, double.
Wednesday, madam? Wednesday.
Thursday.
Thursday. Thursday may not be auspicious for you. And then 22nd half. Dangerous. Maybe it will be dangerous for Mr. Gupta. Other side. Okay, Thursdays.
Okay.
On a request made by Sri S.P. Roy, matter is adjourned to be listed on Thursday. Thursday for disposal.
Okay.
Thursday, huh? Disposal. Yes, next.
Item 3.
Rest of the matter में inspection. Matter में inspection.
Matter may be
Inspection.
infection. Infection, what infection? Go to the doctor if you are infected.
No, my lord. Matter may become inspection.
Wait. Why have you come? What infection do you have?
Inspection.
Infractuous.
Yes.
We thought you were having some infection.
Okay.
Why are you smiling, Mr. Botakur?
My lord has given a good reason.
Is it a good reason? He's having infection, you are smiling. Okay. What is your name?
Hussain.
You are not there on record. We record your name. Sri L. Mohan, Learned Counsel for the petitioner. has submitted that by efflux of time, the matter has become infection,
No, my lord.
infructuous. Also heard Sri I, Bothakur, learned counsel for the PHC, para. Writ petition accordingly stands dismissed as infructuous. Yes, next.
Obliged.
Then fine.
Yes, Mr. Talukdar, what is this?
Lordship, there is an order, Lordship, on 2810, Lord,
Hmm.
directing the council to punish instruction, Lordship.
Dij? Dimaso?
Master, Lord.
Yes.
Lordship, Lordship, we have forwarded the proposal in Lordship.
Finance, anyone is there for finance? Yes, Mr. Borpujari?
Lord, on Lord, 25/9/2024,
Hmm.
a submission was, my lord, made by my lord the NC Hill, my lord, to the effect, my lord, that the finance has rejected the proposal with regard to petition advertisement. We have not received any proposal. We have not rejected any proposal. And our instructions are very clear,
But
my
this
lord.
is made on 10/12/2024, this letter which Mr. Sharma has placed for us. Do you have a copy, Mr. Sharma, of this?
Yes.
Show it to him.
It has been sent at a later date. So I will have to seek instruction on the strength of
Heard
this letter.
Sri H. Talukdar, learned counsel for the petitioner, para. Sri C. Sharma, learned standing counsel, NCHAC, has placed before this court copy of a communication dated 10/12/2024, which has been issued by the executive engineer, PWD, bracket R&B, Maibang division, the Maibang division, Dima Hasau, to the finance department on the aspect of release of pending arrear salaries of the husband of the petitioner.
Husband of the
para. Sri Borpujari, Sri R. Borpujari, learned standing counsel, finance department, prays for and is granted 2 weeks' time to obtain instructions on the said issue. You have a copy of this
My lord, I will collect. My lord, with
to
all fair-
facilitate him to have the instructions, let a copy of this communication be handed over to him.
That may be.
Tell us, list on today's 12th. We'll have it on 27th,
Obliged.
27/3.
With all fairness, my lord, I have to step in. Perhaps this letter will not reach finance department because of the reason, my lord, it has been sent by the executive engineer. This is the, my lord, difficulty that they are causing.
It should
It should
be
go
routed
from,
through
my
the
lord, government to
council.
government. My lord, it is
Should be
the
routed through the council. How does your executive?
hill areas department. From the hill areas, it will have to go.
Copy has
Where?
It is directly addressed to finance department. I don't
Okay,
know.
you take instructions.
My lord, anyway.
There's the second page also. Give the second page also here. Okay. Next.
So, obliged.
Then 15 and 16, copy list.
Please, Lord. So far, item 15 is concerned, my lord. The petitioner has to file reply mail. And she being a widow and her daughter is, my lord, is giving her examination. So she
Reply
could
to
not,
what?
reply to the affidavit dated 24/10/2024, my lord. Filed by respondent number
It was
4,
in October 2024. We are in March 2025.
my lord.
If you wish not to file an affidavit in the last 5 months,
Well,
should you give me time?
Kindly, my lord, someday, my lord, allow me. She being a widow, my lord, and only her only daughter, my lord.
Is it proper on your part to ask for a adjournment, that too for a widow of a matter of
It's
2018?
not proper, my lord.
Then
But for the ends of
who
justice,
is
my lord.
suffering?
For the ends
From
of
18, the matter is is going on. We are in 2025.
Audience of just kindly above.
This matter is going on like there, like adjournment. The promotion, my lordship may kindly take up the matter also to take on hardly 10 minutes. I will dispose of the matter.
What
Both
is
the
your stand in the affidavit?
Our stand is that,
Which
the
department? Transport department?
corporation department.
Corporation department.
Yes. Lordship, both the affidavit filed in Chitralakha Devi, WC number 8602, my lord.
No, Ahmed, for which matter?
16, my lord. My promotion is hanging because of the order passed by this honorable court, my lord.
In the other two cases?
My lord. Same.
In
same
item number 15, well, there is order passed by the
So there is no say, but during the pendency, the department don't want to proceed for promotion, though the
Okay,
petition was
we will
selected.
give a last chance,
yes, my
but we'll fix for hearing,
my lord.
for disposal.
Kindly, my lord, a date may be fixed.
We'll
subject to your
have a
lordship
date. We'll
permission.
have a date.
Okay.
Sri P.J. Sekia, learned counsel for the petitioner, has prayed for time to file rejoinder affidavit. Full stop. On the other hand, Miss M.D. Bora, learned standing counsel corporation department, as well as Sri M.U. Ahmed, learned counsel, appearing for the petitioner in connected WPC 2297 of 2024, have objected to the said prayer as I object to the said prayer. Para. Considering the above, do an adjournment has been granted to enable filing of rejoinder, if any, as a last chance, comma, the matter is directed to be listed on
First we go April.
on 26th of March.
Lordship, from 25th, I'll be out of station till 1st of April.
Maybe first week of April, my lord. If your lordship permission.
Okay, then 2nd of April.
Can it be on
I'll-
3rd of April, my lord? It's a hearing date, Thursday.
For this bench, every day is hearing.
Third of April.
3rd of,
Tuesday will be tired after returning.
yes, I will. Late night, I will be.
Okay. 3rd
Obliged.
Obliged.
Please be obliged, my lord.
3rd of April.
Item 9 to 10.
Election, okay. হেৰিখন লাগিব বহীখন মোক কলা বহীখন লাগিব ই জানিব লেফ্ট চাইডত বেৰত আছে দিয়া কলা বহী মোৰ হেৰিটো থাকিব পাৰে মোৰ এই চুটকেছটো থাকিব পাৰে Somehow we are not having adequate time for your matter. Today we have to rise slightly early because of some, but 1 hour you can easily have.
The other day, Lordship, I have faced the judgment of Dr. Sipra versus Shantilal Kotwal. And in that case, Lordship would recollect 4 cases were disposed of together. And in all the 4 civil appeals, one material fact which is very relevant and which is present in all the cases, that the affidavit was not notarized before the competent authority. In that case, the Honorable Supreme Court was pleased to say that affidavit is an integral part of the election petition, and it is required to be complied with as per the provisions of section 81(3), that the service copy must be identical with the original copy. That is the copy placed before the Honorable Court, and both the 3 judges are on the same footing. And if that lacuna is there, then it is considered that the election petition is not complete, and therefore such election petition is liable to be dismissed in limit. So that is the principle laid down in this Honorable Court. That is the principle laid by the Honorable Supreme Court, and that judgment was of the year
Surprise 96.
96, and the judgment was delivered just
3rd of April 96.
yes. The judgment was delivered on
3rd
3rd April 1996. Thereafter, in 1999, a 5 judges constitutional bench was pleased to consider a case filed by T.M. Jacob versus C. Paulos, which was decided on 15th April 1999, 3 years later, and where there was the allegation that non-compliance of section 81(3). The facts are there, Lordship. I would like to place in short the page 277, where also there is the allegation that 81(3), that means same copy should be furnished to the respondents also. May I place that? Section 81.
Yes.
One. Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petition under his own signature to be true copy of the petition. And when there is an affidavit is required, Lordship, that is 83(2), there should be accompanied by the affidavit, and a format is also given, Rule 94A. That format is also given, and the competent authority in terms of this is that the affidavit has to be notarized before a court commissioner or a district magistrate or a notary. In this case, Jacob's case, affidavit was notarized, but the particulars of the notary was not given. The name and his details, addresses were not given, but it was notarized. So may I place this case? This appeals by special leave is directed against the order dated 18/9/1996, passed by the learned single judge of the High Court of Kerala, rejecting the application made by the appellant herein seeking dismissal of election petition on various grounds. The facts are as the appellant returned candidate was elected to the Kerala State Legislative Assembly from Priyabhom constituency number 79. While the appellant had secured 51,873 votes, respondent number 1 election petitioner had received 44,165 votes. After the results of the election was declared, the first respondent filed election petition number 8/1996, challenging the election of the appellant, alleging that the election of the appellant stood vitiated by the commission of various corrupt practices, as detailed in the election petition. The election petition was registered by the appellant, and on 29/7/1996, the appellant had filed his written objection. Various objections were raised, but for the purpose of this appeal, we are concerned with the objections raised in paragraph 19 of the written objections to the effect of Annexure 15 supplied to the appellant was not a true copy of Annexure XP, that is 15, filed by the election petition, and the election petition was liable to be dismissed on that score alone for non-compliance of the requirements of section 81(3) of the Representation of People's Act 1951. Respondent number 4 to the election petition also raised preliminary objection on 37/2/1996. That objection, however, has no relevance to the present appeal. I'm skipping that part. Paragraph 2. On 8/6/1996, the appellant filed a petition CMP of 1996 praying that the election petition be dismissed for non-compliance of the provisions of 81(3) of the Act. The main objection raised in this petition also centered around Annexure XP report in the newspaper Rashtra Deepika, paragraph so and so of the same. I have filed my written statements of objections to the election petition on 29/7/1996. I have raised a preliminary objection to the maintainability of the petition under section 81(3) of the Representation of People's Act. Section 83, clause A and B contemplate that an election petition shall contain a concise statement of the materials and also set forth full particulars of any corrupt practice. So whenever there is an allegation of corrupt practice, it may be contained in the document, and the election petition may refer to such document. when such documents should be supplied to the opposite party, it forms an integral part of the election petition. In this case, the petitioner had produced Annexure XB, a daily newspaper, Rashtra Deepika, to prove one of the corrupt practices. Though a report is mentioned in paragraph 16 of the election
36,
petition,
36.
sorry, 36 of the election petition, a copy of the report has not been served on me. Hence, I verified the original petition and found that the averments in paragraph 36 of the original petition and the report in Annexure XB are entirely different. Non-supply of the report to me is fatal to the maintainability of the election petition, as section 81(3) of the Representation of People's Act provides for giving a true copy of the election petition to the respondent mandatorily. The copy served on this respondent does not tally with the original petition submitted in the court. Even the contents of paragraph 36 of the election petition do not tally with the statements made in the newspaper report in Rashtra Deepika filed by the petitioner with the election petition as filed in court. As a consequence, there is non-compliance of the requirement provided in section 81(3) of the RP Act, which entails dismissal of the election petition as mandated by section 86 of the RP Act. While CMP so-and-so was pending consideration on 19/8/1996, the appellant filed yet another memo of objection to his advocate, stating that the copy of the election petition served from him was defective. Memo submitted by S. Narayan Koti, advocate for the first respondent in the above case. I am herewith submitting the copy of the election petition 8 of 1996 served on the first respondent for the information of the Honorable Court, especially copy of the affidavit in Form 25. We are concerned about this. In Form 25 as per Rule 94A of the Conduct of Election Rules 1961, in order to show that the verification of the notary public is not contained therein and thereby the copy of the is defective, both the copies served on me on the respondent are identical. Respondent number 1 filed his reply both to the above memo as also to CMP 2903 or so and so. Apart from stating that the objection regarding alleged defect in the supply of the true copy of the petition had been raised after issues have been framed, it was maintained that the objection contained in the memo filed on 19/8/1996 appeared to be influenced by the observations made by court in Dr. Sipra versus Tantilal Kotwal and had no validity. Respondent number 1 stated in paragraph 3 of his reply. Admittedly, in the copy returned by the first respondent, the attestation part is conspicuously present. This is the difference, Lord. The attestation part is conspicuously present. The petitioner had signed the same and the advocate had also attested the same. Above the word notary, it has been shown as signed. Therefore, the petitioner is advised to submit the first respondent is not entitled to draw comfort from the Supreme Court decision, as the affidavit in that case did not contain the attestation part at all. So in Sipra, there was total absence. Here, there is presence of the attestation. It is further elaborated subsequent paragraph. It is also understood that in that case, the attestation in the original was done by the notary by hand in manuscript, and therefore, understandably, the copies did not contain the solemnization and attestation by the notary. The present affidavit does not suffer from the grave lapse, which was the subject matter of scrutiny before the Supreme Court, that is Supra's case. It was further asserted that the petitioner had complied with Rule 94A as well as Form 25 of the Conduct of Election Rules 1961 while filing the affidavit in support of the allegations of corrupt practices, and that there has been no breach of Section 81(3) of the Act. In paragraph 7, respondent 1 stated, the petitioner submits that no prejudice has been caused to the first respondent. If he felt any difficulty in the copies supplied to him, he would not have ventured into filing a detailed written statement of the objection. The petitioner is advised to submit that the first respondent ought to have raised this objection before he filed his written statement of objections. It should be presumed that every allegation contained in the election petition, including those pertaining to the allegations of corrupt practices by the first respondent has been answered by him to his satisfaction in his written statement of objection. Therefore, it has to be understood that the first respondent has taken the copy of the EP served on him as an absolute true copy as he has acted upon it in that manner. After that, the first respondent is not entitled to turn back and erase the effect of the effort he has already made to defend his case by going back in time and raising preliminary objections on maintainability at this stage of the proceedings. In the circumstances, the petitioner most humbly prays that this honorable court may to reject the first respondent's memo dated so and on this ground, urged at the time of hearing during allowing the continuation of the trial of the EP. On 13/8/1996, at the suggestion of the learned counsel of the parties, the following additional issue was raised as to number 1. Whether the election petition is liable to be dismissed for the reasons mentioned in CMP 2903 of 1996. In the High Court, in support of issue number 1, learned counsel for the appellant relied upon the judgment of this court in Dr. Sipra's case. It was submitted that the vice which had been noted in Dr. Sipra's case in the copy of the affidavit served on the returned candidate, along with the copy of the election petition in that case, was also present in the present case inasmuch as the verification of the affidavit on the copy of the affidavit supplied to the appellant did not tally with the verification of the affidavit filed along with the election petition. It was pointed out that neither the name of the notary nor the stamp and seal of the notary has been fixed below the attestation of the verification on the copy of the affidavit supplied to the appellant. So, in the affidavit filed along with the election petition, the name, stamp, and seal of the notary after the attestation of verification by him were very much present. And because of non-supply of the true copy of the affidavit, the election petition suffered from the defect covered by section 81(3) of the Act. The High Court, however, did not agree and found that the vice which had been noticed in Dr. Sipra's case was not present in the present case, inasmuch as the omission pointed out in the copy of the affidavit served on the appellant did not render the copy as not as true copy, and there had been substantial compliance with the provisions of 81(3). Besides, alleged variations could not cause any prejudice to the appellant in formulating the defense.
This is the counter argument.
And High Court's opinion also. The second objection raised in the High Court was about the alleged non-supply of the true copy of Annexure 15 of to the appellant. Insofar as this second objection is concerned, the learned single judge of the High Court compared the copy of Annexure 15 served on the appellant with the copy of Annexure 15 as filed along with the election petition and found that the two were identical and there is no variation between the two. The High Court therefore held that the election petition was not defective at all on that score either. The High Court accordingly rejected the preliminary objection and citing the issue. Number 1 held that the election petition was not liable to be dismissed on the ground raised by the appellant. The order of the High Court had been put in issue by the appellant in this appeal by special leave. This is the background. Now, paragraph 9. After leave was granted by this court, the following order was made on 18/12/1997. The main point urged by the learned counsel for the appellant is that a copy of the affidavit supplied to the appellant together with the notice of the election petition is not a true copy inasmuch as it does not indicate the name and designation of the notary, nor does it bear the seal and stamp of the notary. So, these are the two defects. That name and designation of the notary and the seal and stamp of the notary, but otherwise everything was there. On this basis, it is contended that there is non-compliance of section 81(3) because of which the election petition is liable to be dismissed at the threshold under section 86(1) of the RP Act. Dr. Sorabji, learned counsel for the appellant, places reliance on the decision of Dr. Sipra versus Santilal, particularly the opinion of Justice Paripunam, herein read with that of Justice K. Ramaswamy. Sri Sorabji submits that even though from the supplementary opinion of Justice Bharucha contained in paragraph 17 of the report, identity on this point may not be explicit, but There being no reservation, the opinion of Justice Bharucha on this point is viewed to be construed as unanimous decision that the judge bench. Having heard Sri Sorati, we are not too sure that the principle indicated in the state decision can apply to the facts of the present case, but certain wide observations in the opinion of Justice Paripurnam and Justice Ramaswamy may support the appellant's contention. In our opinion, the matter would therefore require reconsideration by a larger bench to decide whether, even in this case like the present one, decision in Dr. Sipras versus Sentinel can apply. The paper be laid before the Chief Justice for constitution of a larger. Now the larger bench what it decides. This is how this appeal has been placed before the Constitution bench. We have heard so and so, paragraph 12. From a perusal of the order of reference, it is seen that the scope of reference is rather limited to consider whether, in a case like the present one, the decision of Dr. Sipras' case can apply, keeping in view certain wide observations made in the opinion of Justice Ramaswamy and Justice Paripurnam in that case. It would therefore be desirable at this stage to first consider the fact situation as existing in Dr. Sipras' case. A batch of appeals came to be dealt with in Dr. Sipras' case. In all the appeals, the only question that arose for consideration was whether the copy of the election petition accompanied by a supporting affidavit in Form 25 prescribed in Rule 94A of the Conduct of Election Rules 1961 served on the respective respondents, but not containing the verification of attestation made by the district magistrate, notary, or commissioner, could be said to be a true and correct copy of the election petition as envisaged in Section 81(3) of the Act. K. Ramaswamy Justice, who authored the lead judgment, referred to various provisions of the Act and numbers of judgments dealing on the scope of 81(3), read with Section 81(1) of the Act, approving the view of the Bombay High Court in Purushottam versus Returning Officer observed. In Purushottam versus Returning Officer, the present question had directly arisen. In that case, a copy containing omission of vital nature, namely the attestation by the prescribed authority. The High Court had held that the concept of substantial compliance cannot be extended to overlook serious or vital mistakes, which said that the character of a true copy so that the copy furnished to the returned candidate cannot be said to be a true copy. We approve the above view. Verification by notary or any other prescribed authority is a vital act which assures that the election petitioner had affirmed before the notary, etc., that the statements containing imputation of corrupt practices was duly and solemnly verified to be correct statement to the best of his knowledge or information as specified in the election petition, and the affidavit filed in support thereof. That reinforces the assertions. Thus, affirmation before the prescribed authority in the affidavit and supply of its true copy should also contain such affirmation so that the returned candidate would not be misled in his understanding that imputation of corrupt practices was solemnly affirmed or duly verified before the prescribed authority. For that purpose, Form 25 mandates verification before the prescribed authority. The object appeared to be that the returned candidate is not misled that it was not duly verified. The concept of substantial compliance of filing the original with the election petition and the omission thereof in the copy supplied to the returned candidate as true copy cannot be said to be a curable irregularity. Allegations of corrupt practices are very serious imputations which, if proved, would entail civil consequences of declaring that he became disqualified for election for a maximum period of 6 years under Section 8A apart from conviction under Section 136(2). Therefore, compliance of the statutory requirement is an integral part of the election petition, and true copies supplied to the returned candidate should be, as sine qua non, contain the due verification and attestation by the prescribed authority and certified to be true copy by the election petitioner in his or her own signature. The principle of substantial compliance cannot be accepted in the fact situation. Justice Paripurnam in his supplementing view, while also agreeing to the view of the Bombay High Court in Purushottam's case, opined, in my opinion, the above decision lays down that the law correctly and is squarely applicable herein. In particular, the following observations incorporating decisions of the Bombay High Court in election petition 2 of 1990, quoted in paragraph 12 of the judgment of Justice Kaji, was instructive and furnished sufficient basis to reach the state conclusion. The observations are of the following effect. That, however, leaves one question to be considered, and it is whether the copy of the endorsement affirmed and signed before me by the notary designation of the notary and the stamp endorsement regarding the affirmation which he made at the time of making of the affidavit were necessary and essential part of the document, and if these are omitted from the copy furnished, that would render the copy which is furnished incomplete, and the defect would be so glaring so as to negate the inference that the copy was furnished. When Form 25 prescribes a particular form and the copy of that affidavit is to be furnished, it seems to me that the endorsement of the authority before whom the affirmation was made, together with his official designation and the stamped endorsements, are also essential, and without them, the copy cannot be regarded as true copy. It is not merely the content of the affidavit which brings sanctity to the document, but affirmation that has been made, and without the affirmation, it can be no affidavit at all. It is, however, not possible to ascertain from the opinions of Justice K. Ramaswamy or Justice Paripurnam whether the original affidavit filed along with the election petition in Dr. Sipra's case were attested and verified in accordance with law, and whether the defect in the copy of the affidavit supplied to the return committee candidate was only of the absence of notarial endorsement in the copy of the affidavit supplied to the respondents in the election petition, or there was complete absence of the verification of the affidavit by the election petitioner, as well as of attestation by the notary showing thereby that the copy of affidavit supplied to the respondents therein was neither verified by the election petitioner, nor affirmed by him before the notary, nor attested by the notary. So this was the issue, three situations and this is now the next paragraph the Honorable Court clarified now. Paragraph 15. However, Justice Bharucha, in his supplementing opinion, while expressing agreement with Justice Ramaswamy, pointed out the defect in that case of the following words. The question that must be posed as indicated by this court's previous decision is, does the document purporting to be a true copy of the election petition mislead in a material particular? The true copy of the election petition furnished by the appellant, election petitioner, to the respondents, the successful candidate, did not show that the appellant's affidavit supporting his allegation of corrupt practice and had been duly sworn or affirmed. While corrupt practice is alleged, the election petitioner must support the allegations by making an affidavit in format prescribed. An affidavit must be sworn or affirmed in the manner required by law, or it is not an affidavit. The document purporting to be a true copy of the election petition furnished by the appellant to the respondent gave the impression that the appellant's affidavit supporting his allegations of corrupt practice had not been sworn or affirmed by, and was therefore no affidavit at all. It misled in a material particular, and its supply was, as the High Court held, fatal to the election petition. Thus, from the facts noted by Bharucha Justice, it transpired as in Dr. Sipra's case, the true copy of the election petition furnished to the respondents gave an impression that the election petitioner's affidavit supporting his allegations of corrupt practice had not been duly sworn and verified. In our case also, it has not been sworn or verified at all by the election petitioner before the notary, which also had not been attested the same, thereby rendering that the document has no affidavit at all in the eye of law. The defect found in the true copy of the affidavit was thus not merely the absence of the name of notary or his seal and stamp, but a complete absence of notarial endorsement of the verification, as well as absence of an affirmation or oath by the election petitioner. So there is nothing actually, it's a blank. It was in this context the bench has found in Dr. Sipra's case that the returned candidate would have got the impression on perusal of the true copy of the affidavit that there was no duly sworn or verified affidavit filed in support of the allegations of corrupt practice by the election petitioner. It was precisely on account of this fatal defect Justice K. Ramaswamy opined that the principle of substantial compliance cannot be accepted in the fact situation. In Anil R. Deshmukh versus Omkar Singh Waga, the appellant had filed an election petition for declaring the election of the first respondent in that case as void and illegal and for declaring him as duly elected. The petition contained allegations of corrupt practice against the first respondent. An affidavit has also been filed along with an election petition as required under the provisions of Section 83(1)(c) of the Act in support of the allegations of corrupt practice. The affidavit was duly affirmed by the election petitioner before the notary, which had also attested the same, and the notarial endorsement attestation contained all the particulars required by law. However, when the copies of the election petition along with the various documents and the affidavit were served on the first respondent, it was found that the copy of the affidavit did not bear the seal or stamp of the attesting officer below the notarial endorsement after the verification of the affidavit. The appellant had, however, signed the copy of the affidavit below a rubber stamp endorsement of the effect attested as true copy. On account of the above omission, the first respondent and the 10th respondent therein contended before the High Court that the copies of the affidavit served on them were not true copies of the affidavit as required in Section 81(3) of the Act. The issue was tried as a preliminary issue. The High Court found that the copy of the affidavit supplied to the first respondent was not a true copy, inasmuch as it did not contain the particulars of the notary below the endorsement made by the notary. The High Court, following its previous judgment in Purushottam versus Returning Officer, which had been approved by this court in Dr. Sipra's case, held that the defect of omission of the particulars of the notary on the copy of the affidavit served on the answering respondent was fatal and dismissed the election petition for non-compliance of the Section 8.3 of the Act. On an appeal to this court against the dismissal of the election petition without trial for non-compliance of the
It was dismissed on the preliminary ground.
preliminary ground. All these cases are dismissed on the preliminary ground only, Lord. And therefore, all the cases went for the SL. On an appeal to this court against the dismissal of the election petitions without trial or for non-compliance of the provisions of Section 81(3) read with Section 81(1) of the Act. 83(1), sorry. The learned counsel for the appellant submitted that ruling in Dr. Sipra's case had no application to the facts of that case, and the copy of the affidavit served on the first respondent did not suffer from the vice from which the copy of the affidavit served on the returned candidate suffered in Dr. Sipra's case. Agreeing with the appellant, Justice Srinivasan, speaking for the 3 judges bench, to which one of us, CJ, was a party opined, in the light of the rulings of the Constitution bench referred to earlier, we have our own reservations on the correctness of the view expressed in Dr. Sipra, but it is unnecessary in the present case to dwell on the same. As pointed out earlier, Justice Ramaswamy had confined the ruling to the fact situation in that case. Insofar as the present case is concerned, there is no distinguishing factor. There is a distinguishing factor which makes the ruling of Dr. Sipra's case inapplicable. We have already referred to the fact that even before arguments were heard on the preliminary objections by the High Court in this case, the true copies of the affidavit had been served on the first respondent and his counsel. In the fact and the circumstances of this case, we have no doubt that there was sufficient compliance of the provisions of Section 81(3) read with Section 83(1)(c) of the Act, even if it could not be said that the copies served in the first instance on the first respondents were not in conformity with the provisions of the Act. The appeal was allowed and the election petition was directed with right on merit. Now, the distinguishing part. in Anil K. Deshmukh's case, Srinivasan Justice has correctly distinguished the case of Chipra, bringing out a difference in the type of facts found in the two cases. Reverting now to the facts of the present case, a perusal of the copy of the affidavit served on the appellant shows that the copy of the affidavit supplied to the appellant contained the endorsement that the affidavit has been duly affirmed, signed and verified by the respondent before a notary. Pausing here for a moment. In our case, all these steps were not there. Lordship, maybe please to have a look once. In our affidavit, there is absolutely nothing regarding the verification, signature, anything. In the case of this Jacob, all these were present. That is the distinguishing factor, and the Honorable Court has clarified here now how it is different from Cipra's case. In Cipra's case, there is nothing. Lordship, maybe please to have a look. Yes. Both the pages, Lord. And this. Yeah, one is verification, the next is affidavit. One is that form 25.
Attested to be true copy.
Signature of that person, but notary's signature, notary's attestation, it has to be signed before. His own signature will not do. It has to be done before three competent authorities.
Any of the three. Court commissioner,
Commissioner,
notary,
court commissioner, notary, or the district commissioner.
district, district magistrate.
District. So nothing is there, totally blank. So in Cipra's case, this was the case. In Jacob's case, everybody's signature, etc. of the notary is there. The seal and the particulars, that means address, etc. name, were not there. Signature is there. So we'll go to paragraph 37 where it has been clarified.
Yes.
So now, again coming to paragraph 21, I am reading it once more. Reverting now to the facts of the present case. A perusal of the copy of the affidavit served on the appellant shows that the copy of the affidavit supplied to the appellant contained the endorsement that the affidavit has been duly affirmed, signed and verified by respondent number 1 before a notary. So that notary's presence is also there. His presence is indicated there. Under the affirmation of the notary, the word as the notary, that is endorsed as the notary. But his name, his designation is not given in detail. That was the case. That is the distinguishing facts of the case of Jacob vis-a-vis Cipra. And the present case, H.R.A. Chaudhary vis-a-vis Jacob, because they are trying to draw a line from Jacob's case to help them. They have referred to this case.
Now it appears that here in the paragraph 21, within inverted comma, it is written as the notary. It
Yes.
appears that even the notary has not signed.
Absolutely.
But
It has never gone before the notary.
But it said that it's a signed, the origin has been signed, so this has also been said to be signed.
Signed.
SD.
Just like in our official letters,
Yes,
the duplicate and triplicate copy. The words as the notary were written. So in this case, the Honorable Court, Supreme Court says the full man that this is substantial compliance. In our case, there is no substantial compliance and which is incurable. The election petition is defective. It is not complete. May I read further? Under the affirmation of by the notary, the word as the notary were also written. What was, however, found missing in the copy of the affidavit was the name and address of the notary, as well as the stamp and seal of the notary before whom the affidavit had been so affirmed and which had attested the affidavit. The defect found in the present case is almost identical to the defect which has been found in the copy of the affidavit supplied to the first respondent in Anil Deshmukh's case. The defect is materially different from the defect found in Dr. Sipra's case. Nothing more is required. That this constitution bench itself has distinguished the two facts. Sipra vis-a-vis Jacob, Sipra vis-a-vis Anil Des. The defect is materially different from the defect found in Dr. Sipra, where the true copy of the election petition furnished by the election petitioner to the successful candidate did not show that the affidavit filed in support of the allegations of corrupt practices had been duly sworn or affirmed or verified by the election petitioner before a notary, whose attestation was also found missing. So it was neither signed before the notary, nor it was attested. So this paragraph 22 is the clincher to distinguish the fact situation of Sipra with the fact situation of Jacob. The argument of the learned counsel for the appellants both in the High Court and before us is apparently based on the following observations made in the opener, K. Ramaswamy and Parakpuram. I am skipping this. Paragraph 24, reliance on the above observations in Dr. Sipra's case divorced from the context in which the judgment has been rendered is neither fair nor proper, because the factual difference is quite visible, apparent, clearing. So, paragraph 25. In our opinion, the principle indicated in Dr. Sipra's case has to be considered as confined to the facts and circumstances of this case, as opined by Justice Ramaswamy himself, when his lordship observed the principle of substantial compliance cannot be accepted in fact situation. So that is the fact situation where there is no attestation, no signature, no affirmation, anything before any of the three authorities. So that situation, the principle of substantial compliance cannot be accepted. But when it has been done in a particular manner, but in a defective manner, as it is evident in Jacob's case, it can be considered as substantial compliance and cannot be considered to be of general application divorced from the fact situation of a given. So Sipra's ratio cannot be applied in all situations. But one situation in which Sipra's case can be applied is that in that affidavit where is no attestation, no signature before any of the three authorities as present. The notary, the oath commissioner, or the district magistrate. Paragraph 26, I am skipping. It is on the principle how to read a judgment. Paragraph 27. We therefore reject the arguments of learned counsels for the appellant regarding the applicability of the observations from Dr. Sipra's case to the fact situation in the present. The two fact situations clearly elaborated. In the case of Sipra, the principle is correct. Whatever was held by the 3 judges bench and the 5 judges bench also affirmed that in paragraph 25. But in the case of Jacob, the Honorable Supreme Court laid down the different things. And that is because to some extent the affidavit is complete. In the affidavit which has been furnished to the respondents in the present case, not in my submission, is not completed in any sense regarding the statutory requirement. Paragraph 28, thus our answer to the reference is that the judgment of Dr. Sipra's case is confined to the fact situation as existing in that case and has no application to the established facts of the present case, and the wide observations made therein were made in the context of the facts of that case only. So my humble submission is that the fact situation of our present proceedings is identical with the fact situation of Dr. Sipra's, where 4 different cases were considered. In all the 4 different civil appeals, the basic fact was that the affidavit was not verified and attested before the competent authority. And that judgment was rather affirmed by this full bench, constituted of with 5 judges, and there is no deviation from the principles laid down in Dr. Sipra's. paragraph 37. We have already referred to the defect which has been found in the copy of the affidavit served on the appellant in the present case. There is no dispute that the copy of the affidavit served on the appellant contained the endorsement to the effect that the affidavit has been duly signed, verified, and affirmed by the election petitioner before a notary. Below is the endorsement of attestation. It was also mentioned as the notary. So this was, everything was done instead of the name and seal. Everything was. So 90% compliance is there. 10% there was a mistake, or there may be a shortfall of complying with the complete requirement. Therefore, however, as an omission to mention the name and particulars of the notary and the stamp and seal of the notary in the copy of the affidavit served on the appellant, there was no other defect pointed out either in the memo of objection or in CMP so-and-so, or even during the course of the arguments in the High Court or before us. Could this omission be treated as an omission of a vital or material nature, which could possibly mislead or prejudice the appellant in formulating his defense? In our opinion, no. So in this situation, the Honorable Supreme Court has a different opinion vis-a-vis the opinion expressed in Procedural. The omission was inconsequential. By no stretch of imagination, it can be said that the appellant could have been misled by the absence of the name and seal or stamp of the notary on the copy of the affidavit, when endorsement of attestation was present in the copy, which showed that the same had been signed by the notary. It is not denied that the copies of the election petition and the affidavit served on the appellant bore the signatures of the respondent number 1 on every page, and the original affidavit filed in support of the election petition had been properly signed, verified, and affirmed by the election petitioner and attested by the notary. There has thus been a substantial compliance with the requirement of section 81(3), read with the provisions of section 81(1)(c) of the Act. Defect in the supply of the true copy under section 81 of the Act may be considered to be fatal, where the party has been misled by the copy on account of variation of material nature in the original and the copy supplied to the respondent. The prejudice caused to the respondent in such cases would affect the provisions of 81(3) read with section 81(6) of the Act. The same consequence would not follow from the non-compliance of section 83 of the Act. So far as their foundation on the basis of the principles laid down in this case, in my humble submission, that judgment itself clarifies, and which goes in favor of the present, the return candidate, whom we are representing.
Applicant.
We are the applicant. The other day, Lordship was also indicated that the recent judgment 2024 SCC Online Supreme Court 2548, Justice Sudhanshu Dhulian, Justice A. Amanullah's judgment. Lordship, I have gone through that judgment and I would like to place few small paragraphs. The fact situation is totally different. The line of argument is totally different. The application which was filed, that is also in a different context. Paragraph 2. The appellant before this court is a member of Legislative Assembly and was elected from 46 Cycle Assembly in the 12th general election of Manipur Legislative Assembly held in 2022. The respondent, who was also a contestant from the same seat, filed the election petition before the High Court of Manipur challenging the result of the election on the ground that the appellant had not disclosed her assets in her nomination paper and that she had indulged in corrupt practices in the election. The appellant filed an application under Order 7, Rule 11. We have filed that application in a different proceedings, but that petition is not before this Honorable Court. Order 7, Rule 11 of the CPC. Read with Section 86 of the RP Act 1951 for rejection of the petition which was dismissed. The application dismissed by the High Court on 5/7/2023 is presently under challenge before this court. The respondent in this election petition inter alia raised the following grounds. two grounds are there. One, because the appellant has been declared as the returned successful candidate by improperly accepting the nomination despite the concealment of the assets and investment of about rupees 2 crore for land development in the state property of land and construction inside the agricultural land mentioned in her Form 26 affidavit. Because the appellant had concealed her total income for the financial year 21-22 and shown as rupees 0, even though she was serving as committee officer of at Secretariat of Meghalaya Legislative Assembly till 31-1-2020. So these are the grounds. These two grounds have absolutely no relevance in our case. Here, one affidavit has to be filed, that is Form 26, along with the nomination paper. In that nomination paper, she had not disclosed the asset, and also she is saying that she is not having any income and her income was shown as 0, whereas she was working till 31st December 2021 in Meghalaya Legislative Assembly as a committee officer. So she was earning salary. So she did not disclose her income and she did not disclose her land property. In that context, the election petition was filed. Now, therefore, paragraph 4, before the High Court, the present appellant then moved an application under Order 7 Rule 11 for rejection of the petition on the ground that it does not disclose any cause of action, as it does not specify any corrupt practices alleged to have been committed by the appellant, nor is there any averment regarding concealment of her income assets. Therefore, the election petition does not comply with the requirement of Section 83 of RPA and ought to be dismissed at the threshold. Our case is 81-1. Our case is on a totally different provision of law. Our case is, Lordship, Section 81(3), presentation of the petition. 81(3) says, every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be true copy of the petition. We are on a different footing. Our allegation is that the affidavit is defective and the election petition is defective because it was not done as per the procedure laid down to make the election petition complete. We are not highlighting anything whether he has closed or concealed any particular factual situation. And we are also harped upon Section 83. 83(2). An election petition shall concise statement of the material full particular corrupt practices, and also an schedule or annexure to the petition shall be signed by a petitioner verified in the same manner as the that verification part 83(2) and 86. We have also filed the application under 86, but our ground is different. What we have said, our entry to the Honorable Court is through Section 86, alleging violation of 81 and 82. Here, what they are saying, their application is 86. They have entered the court for dismissal of the petition, but
711.
711.
No, 711 is okay.
Yes,
You
Lord.
can-
That no cause of action is
No
there
cause-
from the particulars
Yes.
given in the election.
Yes.
So totally, that is why this judgment, in my humble submission, is not at all relevant for our present adjudication. Let us go a little bit further in this judgment.
Your petition is under 86.
86. It has nothing to do with Order 7 Rule 11. And our case is violation of 81(1). In the others case, it is 83. And on top of that, no disclosure of fact, cause of action.
81.
So
But, Mr. Sekya, if you come to 86.
Yes.
86.
the
it
High
is
Court
a-
shall dismiss a petition,
Yes.
an election petition which does not comply with the provisions of 81 or 82 or 117. There are three different areas. Here 81 is there. We are on 81.
No, no. So far as the Hawkip case is concerned, it is not filed for violation of 81, 82, or 117.
Absolutely not.
They say there is violation of 83.
83.
83, where the corrupt practices, those are not met. So 711 has been filed.
Lot. So that is why how to deal with the case in which the allegations and the grounds are totally different can be taken from a principle laid down in a case which was considered on a different footing. The facts are totally different. I mean, the facts are not even close. So may I continue? So paragraph 4 before the High Court, the present appellant then moved an application under Order 7, Rule 11 for rejection of the petition on the ground that it does not disclose any cause of action. We have not alleged that in our case, as it does not specify any corrupt practice alleged to have been committed. That is not our by the appellant, nor is there any averment regarding concealment of her income assets. That is also not our case in this petition. In the other petition, of course, but that is not being heard at this stage. When that situation will come, we'll argue on a different where this case may become stamp relevant. I do not know. We have to find out everything. Therefore, the election petition does not comply with the requirement of 83 of RBI and ought to be dismissed at the threshold. So, the three allegations and the grounds have no similarity with the grounds and the allegations which we have raised in our present proceedings under section 86. Only thing is that 86 is common. 86 which says trial at the High Court shall dismiss an election petition which does not comply with the provisions of 81, 82 and 117. However, their case, although I think they have also got the dismissal order, I am not going to the last part, but specific provision where there is the allegation of violation is 81, 82 and 117. So here our case is on 81 and 82. Their case is violation of 83.
In that Hawkip case.
Hawkip case. Paragraph 7. Over the years, election petitions have been filed invariably on the grounds which are similar to the ones raised before this court. The only question is whether the court can dismiss such a petition at the threshold on an application under Order 7, Rule 11 of the CPC, or that the petition needs a detailed consideration by the court. The answer to this will depend upon what kind of statutory compliances have been made in the election petition. The case of the present appellant before this court is that if the provisions as referred above, wherein material details have to be given by the election by the respondent, and particularly the details of corrupt practices, etc., has to be strictly construed, and any deviation by the respondent on this requirement shall make the petition liable to be dismissed at the very threshold. So the whole case is based on the ground that detailed particulars of corrupt practices were not placed or mentioned in the election. Our case is everything is placed, but it has to be substantiated. It has to be supported by a verification as well as by an affidavit in Form 25A as per the 1961 rules, 94A provision. So that is on a totally different ground, different facts which we are highlighting. All the same, this is not what is the requirement of law. Rather, the settled position of law is here that an election petition should not be rejected at the threshold whereby there is a substantial compliance of the provisions. In our case, what can be considered as substantial compliance and what cannot be considered as substantial compliance, Jacob's case is very clear about that. Two situations were visualized. One, the affidavit with no signature of the notary, no signature, no seal, no attestation. The other one is signature, etc. is there. Only the name and the stamp is missing. So in the first situation, the Honorable Court by 3 judges as well as the 5 judges bench opined that that is a non-curable defect. The affidavit is defective. The election petition is not complete and it cannot be cured. That is the situation of the present procedure. Here 8. Thus, we will have to see whether substantial compliance of section 81(1)(a), 83(1)(a), 83(1)(b) has been done by the election by the respondent. So now here, the Honorable Court was scrutinizing the provisions and the materials before the Honorable Court in the Supreme Court, whether it has complied with section 83(1)(a). That means shall contain a concise statement of the material facts on which the petitioner relies. So we are not on this in our case. Then 83(1)(b). B says, shall set forth full particulars of any corrupt practice that the petitioner alleges, including a full statement as possible of the names of the parties alleged to have committed with such corrupt practice and the date and place of the commission of each such practice. That means the details of the corrupt practice. Nothing more, nothing less. So whether
But
these
one thing, 83, we have understood your contention. 83 is on the aspect of corrupt practices,
Lordship,
which requires a more stringent measure
yes,
from the person who makes an application,
Lord,
which another verification, another affidavit. Now, this a similar situation arose in the case of Sideswar, where for the purpose of affidavit, for the aspect of affidavit, it was held to be substantial compliance. In the case of Sideswar.
substantial compliance.
Yes.
Yes. In that case, Lordship, we have to first give the particulars and to support the particulars of the allegations regarding corrupt practices. 83(2). Any schedule or annexure to the petitioner shall also be signed by the petitioner and verified in the same manner as the petitioner. And for that, we have to read with Rule 94A. Now let us go to Rule 94. (94A). Have got it?
Yes, just a minute. Yes.
94A.
Form of affidavit.
Form of affidavit to be filed with election petition. The affidavit referred to in the provision of subsection 1 of section 83. That means corrupt practices detail.
Correct.
Shall be sworn before a magistrate of the first class or a notary or a commissioner of oath and shall be in Form 25. So now let us go to Form 25. Form 25, Lordship will find. If Lordship is carrying the same book, page 330. Here, the details are there. And lastly, solemnly affirmed, sworn by Sri so-and-so at so-and-so, this day of so-and-so, before me, magistrate of the first class as notary
Yes,
shall
same requirement as given in Rule 94A.
Exactly, Lordship. So
But
this requirement they have
in this case, see, this requirement is also of a notarization or attestation by a particular.
But here the allegation is not on that. The allegation is affidavit, etc. are there. But the particulars are not there. Detailed particulars. The particulars now today, for last 15 days, lot of bail cases were cleared by the Honorable Court. Why? the ground of arrest and reason of arrest in
Because yes.
the details. The
Yes,
details
yes.
regarding the ground of only case number, provisions under which the case is registered, that is not sufficient.
Reasons not given.
The details must be in two says details.
Recent judgment.
I say that
Justice Oak.
my colleague Padma Nayak is doing corrupt practice, but I have to give
But
details.
kindly see, today we will have to rise 2013 4 SCC,
2000
13 4 SCC 776.
will go to that lordship next year.
Because in that case, though it was a case of corrupt practices, but the objection was on the affidavit part.
Lord.
Even in that case, court has said that yes, it may amount to
Curable defect.
no, substantial compliance.
Substantial complaint. Now, here also,
Okay. Okay, when can we have? Tell us today, because of this meeting, we have to rise.
today, day after tomorrow, it is the holiday.
Day after tomorrow.
So-
Next week.
Next week, lordship, just 1 second, because lot of cases were fixed. Monday, I am free, lordship, just 1 second. 17th, Monday.
Senator?
Well,
17, we
the
try.
sooner the better, lordship. Otherwise, we also forget it.
What will happen to the court?
Go court. Master with lordship.
Three. This Learned Senior Counsel had continued his arguments, which has remained arguments
Yes,
which have remained inconclusive. Sarah, please for further consideration on 17th. Okay. এখানে